Good morning, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. Let's get our day started with Judge Dad up in Michigan.
Oh, Megan McNally.
Oh, no, I just have these two. I'm sorry. All right, so how much do you have today? Anything?
Yeah, you told me if I came in, with it possibly lower. With it possibly lower. Like a month ago, and I got 400.
You have $400?
Yeah.
I can't lower it that much. I mean, you're looking at, you owe $610.
But no. I'm just trying to get this stuff up.
I can't do that. On file A, you owe $248. I'll lower it to $195. You pay that in full today. And on the other case, that's on the A file. The B file, you owe $362. You pay $265 on that one. That would make it $460. Can you come up with another $60?
Not today, I wouldn't be able to, but I can give the 400 at least today.
You have it with you, right?
Yes.
You pay $205 now. Pay $205 today. 50 more by 10/24. That's a week from Monday. I'll waive the balance, but you still have to pay the clearance fee, okay?
Okay, how much will that be?
$45 for the clearance fee. So if you pay 400 today, come in with 95 next week, that will give you your clearance fee, and that will give you that will satisfy all these, okay?
Okay.
So 95 more by next week, but you still don't have a license till you pay that $45 clearance, okay?
Okay.
And I don't know what the status of your license is otherwise. Good luck.
Other tickets I'm paying off.
Good luck. Thanks. Alice and Jean Kimball, 25M600497 A and B. Your name?
Allison Gilbert.
You're charged with operating a motor vehicle without security. You also have violation of the seatbelt law. You have the right to a lawyer on this. Really, they need to get a complaint and an authorization from the prosecutor if they're citing you with no insurance. So that's a 1-year misdemeanor, but they haven't done it right so far. So I'm going to turn this back. If you want a lawyer, I'm going to give you a lawyer. Let's start with that. Do you want a lawyer?
No, I don't have.
Oh, Mr. Mohammed, can I have your name, please?
Good morning, Your Honor. Mohammed on behalf of the people.
I have an Alice and Jean Kimball here. The trooper wrote no insurance under the statute, which is 1 year. He has it on a citation. I think you require, and actually, you can't do it just on a citation. It has to be authorized by a complaint on a 1-year misdemeanor. So she's got no insurance. And she also has a second charge, a seatbelt violation. She's waiving her right to a lawyer. I'm going to arraign her, and I'm going to let you take care of it then, okay? So, ma'am, I want you to understand, they need a complaint that's authorized by the prosecutor's office on anything punishable by in excess of 93 days. So this is punishable by 1 year. No insurance at all, meaning not only didn't you have it with you, you didn't have it. And then you also have a charge here of a seatbelt violation, which is a civil infraction. Do you understand that? Did you sign the advice of rights and read and understand the rights? If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes.
You still wish to waive your right to a lawyer?
No.
You want a lawyer now? Enter a not guilty plea, $500 personal bond. You cannot leave the state without consent. You can't violate a law. You must appear in court as directed. You can cover that with the defense lawyer if you would too, Mr. Mohammed. I'm sure they'll know, but you just don't see them write no insurance citations. Okay, so we'll get you a lawyer. You can go out in the hallway. Just be patient. It'll take a minute. Okay, thank you. Gerald Paul Ostrike, 25S569592. Good morning, Heather.
Good morning, Judge.
Good morning, sir. Your name?
Gerald Oster.
Okay, it's 2 minutes to 9, but I'm going to call your case early. The officer is here, so we'll take care of this right now. We need Corporal, I believe it's Corporal Cadez. It could be Sergeant, but Sergeant Cadez, I'm sorry. Sergeant, tell me your name, please. I just called the O-Strike case. Good morning.
Good morning, Your Honor. Sergeant Rick Cadez, Wayne County Sheriff's Department.
You got him speeding, and is there an offer here? It looks like his record is clear.
Yeah, we'd be willing to offer impeding traffic.
You want to plead to impeding traffic, Mr. O-Strike? That's 0 points. It won't go on your record.
Yes.
To the charge impeding traffic, responsible or not responsive. Plea is accepted, speeds dismissed, 150. You are all set, and I wish you well. Good luck. Thank you. Yes, sir.
Where do you like to see that?
You can go right down the end of the hall to the cashier.
Thank you.
Thank you.
You have a good day, Your Honor. That was my only one.
You too, Sergeant. Thank you very much. Bye now. He's saying no objection, defense's motion for early discharge if defendant in full compliance. Well, it looks like you're in full compliance. This is People Against Ali Aziz Naji, 24W7046801. Your name?
Ali Naji, Judge.
Raise your right hand. You solemnly swear or affirm under penalties of perjury, the testimony you've given these proceedings will be the whole truth, so help you God.
Whole truth and nothing but the truth.
Since you were in court in front of me, have you been arrested for any reason?
No, Your Honor.
Any new charges?
No, Your Honor.
Any contact with the police?
No, Your Honor. Absolutely not.
Mr. Mohammed, can I have your name, please?
Good morning, Your Honor. Mohammed coming up ahead of you.
All right, so I understand what your note says here, and that's fine. It's just they've done it for 30 years the other way, but that's okay. We all change things. I just want to make sure that I understand. Especially when somebody's applying for early discharge. And that's what they're doing here, right? He was placed on probation for 24 months back on September 17 of 24. So he's applying for early discharge, but the case was taken under 7411. You're not going to motion for it, but you don't have any objection to the case being dismissed at this point. Good enough. Case dismissed, defendant compliant. You are all set, sir. I wish you well.
Thank you, Judge. Thank you, Mohammed. Appreciate you guys. You guys made the right choice. God bless.
Have a good day. Thank you.
And Judge McNally made the right choice. All right. Good morning once again, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. Let's go to Florida. Wade Mercer.
Brother and your uncle are both in the courtroom. Miss Geyer, you're here because you've been accused of one count of leaving the scene of an accident with property damage without giving the information required under Florida law. Miss Geyer,
Yes, sir.
there is probable cause.
It was a different charge. It was unattended, leaving an unattended vehicle.
Who's leaving the scene?
No, it wasn't leaving the scene. It was leaving an unattended vehicle.
Failed to leave information, unattended vehicle property damage. It's what's known as leaving the scene. It's that I think that Mr. McDaniel is right. The statutory name is something different. So, Ms. Geyer, that's what you're accused of. There's actually a bond already on the warrant. Let me see if Mr. McDaniel or Mr. Mitchell have any additional information. Mr. McDaniel?
Your Honor, we want to take care of this morning. I think Ms. Geyer wants to just speak to the court, and we're going to take care of it there.
All right, Ms. Geyer?
Yes, sir, Your Honor. I've been incarcerated since September 12th of last year. I know that my family's been in constant contact with y'all. My mom, my uncle, who's in the courtroom, has been talking to y'all, the courts, your secretary. It should be in your notes that I've been in constant contact. You know, I even asked Judge Roberts, sentenced, and when I was sentenced to DOC, if I could get over here and handle this before I went. DOC, I've been trying to take care of it left and right. You know, I've just served 13 months, a little over 13 months. I do apologize for leaving the scene like I did. You know, my family's in the courtroom right now. You know, we were intending on me getting out today. You know, is there just anywhere that you can have mercy on me?
Ms. Geyer, what you went to prison for has nothing to do with this. In fact, you had the warrant for violation of probation when you backed into this person's car, left, and then admitted to it according to the complaint. That's what the complaint alleges. Has nothing to do with it. So when you were in prison, you filed a plea, trying to enter a plea to time served without ever having served one day in jail, and that all court costs and fines be waived. I rejected that. It's just not how I do things. So you've got an offer made today. You also have a bond set, which you choose is entirely up to you. But as far as someone just saying, well, she went to prison on something totally unrelated, so we're just going to forget about this, I'm not going to do that. So would you like to try have a chance to post a bond that's been set for you, or do you want to enter a plea to take the offer that's been made, or do you just want to get Mr. McDaniel to work on the case for you a little while and see if he can get the offer any better?
Okay, I also have a TPR hearing, the termination of parental rights hearing on October 20th. I've been getting it pushed back. I've been fighting for my kids this whole time. So that is an in-person hearing at the Washington County Courthouse. That
That's not answering the question.
I understand that. I'm going to take the plea deal. I mean, if that's
Your Honor,
what
we're
it
going to
is.
enter a plea of no contest to the charges listed. You understand, and should be sentenced to 30 days in the county jail, 1 day jail credit. She's waived the right to jury trial and call witnesses. $370 fine. Hopefully she'll work it off while she's in the jail. She did have a civil ticket, but she paid that civil ticket while she was trying to take care of all these other issues and whatnot, for backing into someone. And that will resolve this case this morning.
And Mr. Mitchell, is that agreeable with the state?
It is, Your Honor. How many days credit does she have?
1 day.
Just 1 day.
Has she actually, Ms. Geyer, have you actually finished your DOC sentence, or did they let you come before you finished it?
Yes, sir. Today was my EOS-8.
Okay. And Ms. Geyer, is this the plea you would like to enter?
Yes, sir.
Ms. Geyer, I will accept your plea of no contest to the charge of leaving the scene, leaving information of unattended vehicle with property damage. Ms. Geyer, I'm going to judge you guilty of this offense, sentence you to 30 days in jail, give you credit for the 1 day you've served, or 300. Is it 370 or is it? It's 400 for that charge. That's a traffic offense. It's $400 court costs and fines, 1 day credit. Ms. Geyer, no probation involved in this sentence. So Corporal, that TPR hearing is something that's a very, very important hearing. So tell me the procedure so Ms. Geyer will know. Is there a court order required to take her to that hearing in Washington County, Corporal, or is there another process we can get her over there? I can't hear anything she's saying, whoever it is talking.
We've been in contact with the contact. We've been in contact.
They're going to do an order of transport.
Okay. So Ms. Geyer, I want you to be available. I want you to make that hearing because, as you know, that's a really important hearing for you. I understand that. So I'm asking the corporal to make sure that happens. If that can't happen, do you have an attorney in that case, ma'am?
Miss Sandra Painter out of Jackson County.
Okay, so just make sure, Corporal, that if something happens with the transport and there's no court order, make sure Ms. Painter knows what's going on so they can deal with it. She's probably the one preparing the court order for the transport, so she's probably going to be in the loop. Ms. Schuyler, this resolves this case. This case is over with. As far as I know, this is the only thing you had left when you got out of prison, so I do wish you the best. You have any questions, ma'am?
No, sir, just thank you.
I wish you the best, ma'am. Any questions from the family? No, she's got a 30-day jail sentence and she's done 1 day on it. So she's got 29 days left, but she very likely will do less than that under Florida's game time law. She may get, I guess for that amount of time, she could possibly get up to 10 days off of that sentence. If she gets all the game time, she may get under Florida law, but that's between her and the jail. I can't promise that. Okay. Thank you. Demetrius Richardson is next. Mr. Richardson, good morning. You're here because you've been accused of violating the terms of your state probation. Mr. Richardson, I'm going to arraign you this morning, and what that means is I'm going to go ahead and get you a lawyer appointed so we can get your case moving if you want one. Mr. Richardson, would you like to have an attorney appointed to represent you?
Yes, sir, I do.
I'm going to appoint the public defender's officer to represent you, Mr. Richardson. Listen to Mr. McDaniel, and then we'll see if you have any questions.
Your Honor, we're going to enter a plea of no contest. We're going to enter a plea of not guilty. As said this on November 6th arraignment docket, and I advised him, Mr. Green, will probably see him. It'll more likely to be the other attorney whoever's representing him in the felony case. I think that hearing is November 4th, so it'll probably happen on November 4th.
Thank you, Mr. McDaniel. Mr. Mitchell, anything?
No, Your Honor.
Mr. Richardson, any questions?
No, sir.
All right, Mr. Richardson, wish you the best. Mr. Green will see you before your court date, sir.
Yeah, the new law's
Thank you,
November
sir.
4th, and then the BOP is November 6th.
Next is James Wirestick. Mr. Wirestick, good morning. You're here for first appearance accused of 1 count of no valid driver's license. There is probable cause in that complaint, sir. I'm going to appoint the public defender's officer to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, we're going to enter a plea of no contest to the charges listed. The understanding, he has been sentenced to 60 days in county jail. He have 1 day jail credit. You have $400 fine. He has waived his right to a jury trial and call witnesses.
Mr. Mitchell.
That is agreeable with the state, Your Honor.
Thank you. Mr. Wirestick, is that the plea you would like to enter, sir?
Yeah, if I can't get out on no probation, yes, sir.
Yeah, I'm not going to give you probation. You just got a jail sentence in Washington County for the same thing in March, I think it was, after a
Yes,
BOP, matter of fact. So you don't have to take this offer. I'm glad to set you a bond, but if you want to resolve it, that's the offer today. Is that what you want to do, sir?
Yeah, if I do a bond, well, I'll have to come back before you and you'll probably give me 60 days anyways,
Well-
right?
Well, let me, that's a fair question. Now, let me try to answer that as fairly as I can. If the circumstances are the change, that may be the offer then. But what happens sometimes is someone will post a bond and they will get their license. And then Mr. Mitchell will say, Judge, since he got his license, we'd like for you to do blank. So if you can get a license, your offer may change. Otherwise, I don't know that it would change without getting a license. It could, but normally a license is the most normal thing that will change the offer. Mr. Mitchell, did I explain that accurately?
Yes, Your Honor.
So it's up to you. If you want to post a bond and try to post a bond and see if you can get a license, that it's not going to get any worse. It may actually help. But if you want to go ahead and resolve it today, as soon as you resolve it, you start getting game time under Florida law. You can't get game time until you've actually been sentenced under Florida law. So would you rather try to post a bond or do you want to resolve it today, sir?
Yeah, I'll resolve it today, Your Honor.
Okay. Mr. Wirestick, I'm going to accept your plea of no contest then to the charge of no valid driver's license. The judge who guilty of that offense sentence you to 60 days in jail. You have credit for 1 day you've already served. Mr. Wirestick, you do have $400 court costs and fines. And like you heard me explain to the last individual, you certainly may get some game time under Florida law. I hope you do. In order to do that, you simply got to follow the jail rules. Stay out of trouble in there, and you very well may be entitled to some game time. I can't promise you that. I'm just telling you that's between you and the jail, but Florida law does allow that as long as you don't have any disciplinary issues while in the jail. Mr. Wirestick, no probation involved in this sentence. You finished this sentence, sir. This is all behind you. Any questions?
No, sir.
Mr. Wirestick, wish you the best, sir. And Mr. McDaniel, that's everything I had on my first appearance list. Anything?
Short list of first appearances this morning. A slow day in Judge Mercer's court. Hello, Ellie. Let's go to Judge Stevens because I just heard him make an interesting comment to this defendant, and I have no idea what the context is. So I've rewound us just a bit, and let's see what's going on there.
Let me ask you something. You're Christopher Henna. How do you pronounce your last name? Wilson. You're here with your attorney.
Yes, sir.
Mr. Adams. I'm looking at this indictment. And I'm just asking you, do you have a mental problem?
Yes.
You think that's funny?
No, sir.
How many family assault convictions do you have?
Yes, sir.
4? Maybe? You got one. You're charged with one here, continuous violence of a family. You got an illegal possession of a controlled substance conviction in 2013 out of Fort Bend County. You pick up a assault family assault in 2018 out of Harris County. Then you just move around the state and just assault people. Then you've got another in 2020, a family assault conviction out of Fort Bend County. Oh, here's one. We've got another family assault conviction. These are all felonies out of Harris County, Texas. Now you want to come into Jefferson County and make a mess, mister?
No.
Are these women that you're assaulting?
It's a woman.
Is it?
It's a woman.
Is it?
Yes.
Okay, Mr. Man. What are we going to do
Just
to the person who assaults females regularly?
just with this being his announcement, I'm sorry, initial appearance, I was gonna put it on the announcement.
He's
do
a
have an offer.
habitual felon, right?
Right, and I offer.
He's looking at a minimum of 25 up to life imprisonment, right?
Right.
That's minimum. Okay.
I just don't, I don't want to put it.
I think a jury wants to hear this in our county. This isn't where he's going to end up to assault. For his long history of assaults, we're not going to end up here. You're going to go to trial. We're going to let a jury here in Jefferson County decide your fate.
Yes, sir.
Because they really don't find this sort of behavior amusing here. And you've moved around the state. How many different counties have you been convicted in for felonies? 1, 2, 3, 4, now 5. You sure there's nothing wrong with you mentally?
Not that I know of, sir.
Not that you know of? You don't know the difference between right and wrong?
Yes.
Do you know the difference between assaulting people, that's a crime and that harms others?
Yes, sir.
You've been convicted several times of this, so it's not like it's their problem. It seems to be yours.
Yes, sir.
Well, we're going to stop the problem in this court.
Yes, I understand.
All right. What do you want to do next? Was this an initial okay?
Yes, sir. I was gonna put it to the announcement, but I think what you're saying is you want to put it on the trial docket, right?
Yeah. Yeah.
He's gonna put it on the trial.
And here's another situation. Who is this? I'm not going to name the person that you assaulted because I don't want to. I'm sure they've been embarrassed enough by you.
So
you're going to interrupt me too?
also, I apologize.
You get to speak. You have a fair opportunity to speak, but I sense your personality is dominance over others. That you're going to keep interrupting me?
Sorry.
And proving it?
Yes.
You finished? Now can I speak?
Yes.
Mr. Rude Guy? All right. All right. What was the relationship of this person to you?
That's the mother of the children.
The mother of your children?
Yes. She does have a lot of mental issues.
What did you just say?
She does have a lot of mental issues. She actually.
She's not the one convicted here 5 times.
Yeah.
You're believing.
I'm not believing.
That's the jury's going to love that when you get to speak. Yeah. I don't mean to be facetious, but this is extraordinary. Generally, people don't show up with a rich criminal history. You know, you were a habitual felon 2 convictions ago. You had reached habitual felony status. You were looking at 25 to life before the last 2 convictions, which are the same type of offenses that you're here for today. Well, do you have any contact with this person other than when you assault them?
I haven't recently. No, sir.
I want to know when you do. The next time you do, your bond will be revoked. You have no contact with this person. If I find out,
I'm sorry about that.
when you're through talking, again,
No,
Mr. Interrupter,
I'm sorry.
what a bully. What a bully. I can see how you would bully women. Yeah, and have a rich history of it. Convictions of assaulting women. Well, it's going to stop. I find out you have any contact with this person, your bond will be revoked and you can sit it out in jail until we get around to trying this. Plus, you're going to have a GPS device. You have one now?
Yes, sir.
So that if you have any contact, we'll be able to find out where you were at any given time. You understand?
Yes, sir.
All right. Okay, put on the trial docket. Thank you. That's all.
That is so going to be its own video. Mr. Rude Guy, Mr. Man, Mr. Interrupter. He's in a mood today, so we're going to keep an eye on this court. Let's go across the hallway. Judge West.
Morning. Are you Asa Jones? And Mr. Jones, in cause number 25 DCCR 0963. My computer's going slow. Give it a minute. You're charged with a first-degree felony offense of aggravated assault by discharging a firearm from June 12th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is a minimum 5 years in prison up to 99 years or life. Do you understand? Answer out loud, please. And I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for 15 years in the institutional division of the Texas Department of Corrections. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are. Do you understand all of that? And do you want to reject that offer and have your case set for trial? I also want to make sure you understand, Mr. Jones, that after today, unless there's some new evidence that the assistant district attorney or your attorney gets or finds out, that this offer will not be accepted after today. Do you understand? Okay. And so, Mr. Jones, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial probably a little quicker. Is that okay with you? All right, Mr. Parker, you're released. Mr. Jones will appoint someone today. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. Carl Leday, Mr. Parker.
If I could have a moment, Judge, he was
I'll
not
hold
at the
him.
jail, so I need to talk to him.
Sure, I'll hold that. And then Perry Robertson,
We're about to, I have a new offer I need to sign.
I'll hold that as well. And Kaylin Welcome,
I believe that's been a rejection based on what he told me.
I'll hold it as well. All right, I'll let you work on all those.
Sorry.
Oh, you're good. Oh, do you want to deal with, what do we have?
There's a.
State's motion to increase a bond. Do you want to get these others taken care of, or do you want to?
I think we can do it now. I mean.
Stephen Boudwin,
Yes, ma'am.
come up, please.
And Judge, I have several things on the record about this.
Sure. All right, sir, you're Stephen Boudwin?
Yes, ma'am.
And let me get this pulled up. Is it,
And so if I can,
hold on just a second. Let me just get it, get what I need to, and then I'll let y'all. Oh, this is, I know. Would you call the name Tiffany Guillory, please?
This is the one I talked to your honor
Yes.
about on Friday. She bonded them out.
She actually, I wasn't sure about this, when I first, he called me yesterday and, about a bond here. I was thinking it was but I had requested a bond, didn't realize what it was. I said, well, you probably don't need to be there because he's already pled out on the case and we were waiting on a PSI. And, we were looking at, we were gonna see what happened with parole. I think he's been released from parole. The parole hold's been lifted.
No response.
And then I get a call from her and she started explaining. I said, well, he needs to be there for the bond hearing. I don't know all the ins and outs about the issue about the increase of the bond, but she informed me as well that she had signed the bond to bond him out, and she sent a letter to the court, I believe, which was
I
forwarded
have it.
to me. And I told him that he needed to go and contact the probation department to do a PSI. I mean, I just told him yesterday, I don't know if he's contacted him yet or not.
Yes, they scheduled me to come in today. Told me to come in off the court.
Ms. Malfino?
Thank you, Judge, and thank you again for your time while you were on vacation this weekend. And I was dealing with this matter with Ms. Guillory, who came to my office in tears, also tried to come to the court. I confirmed with your coordinator about that, in tears, about how fearful she was of this gentleman. So I immediately turned around and filed a motion to increase his bond, which time your honor graciously added some conditions of a GPS, et cetera, et cetera. I spoke with parole on Friday before I talked to you, Judge, and they were going to lift the hold. So that's when you put those conditions in place. I since have learned that obviously Ms. Guillory has now had a change of heart. She actually posted the bond herself. I was going to ask the court to reject the probation offer that I had given him, but in light of her actions, obviously I filed it, as the court knows, and you and I have both experienced, when someone expresses that level of concern, it's not something that we take very lightly, and yet her actions have proven that that was not serious to her, even though we all took it seriously. And so I would leave whatever decision you make, Judge, to your discretion. I'm not really concerned about the bond at this point.
So here's the thing, Mr. Boudwin, I'm not going to increase the bond based on what we've learned. However, a condition of your bond is still, and what has been the whole time, that you have absolutely no contact and no communication at all with Tiffany Guillory. She cannot give you permission to violate that order. Do you understand? So I understand she wouldn't bonded you out. She's written me a letter. At this point, I don't care about any of that. Period. Now, once you're on probation, maybe some of that will change, but as of right now, no communication, no contact. That's in person, that's through your phone, that's through sending messages. Again, she cannot say, it's okay, I won't tell. If something happens and she changes her mind again, which is likely, it sounds like, and contacts Ms. Malfino and says, okay, I thought it was okay, but now it's not, he's coming around, you're going back to jail and you probably won't have a bond. That's how serious I am about this. Okay, so we'll reset it. You need to take care of your pre-sentence report. You need to talk to probation, go there today, get that set up, and then we'll see where we are when we come back for sentencing. And you have that GPS device on? Okay, make sure you keep it charged, make sure you pay for it, do everything you're supposed to, so that I know at all times where you are.
I assume the sentence is still the same as on the 18th?
Yes.
Okay. Okay.
All right, okay, you're free to go.
Thank you, Judge. I just felt it important to document.
Bailey Silver Gavel Club. Congrats, man. Go back across the hall.
That's all I want today, from initial to announcement.
Yeah. The victim in this case, Mr. Livingston, do you know the burglary victim here?
It was my sister's friend's mom's boyfriend.
Okay, you can't have any contact with these people. You heard what we talked, and that's a condition of bond anyway. I just warn people because they go, oh, I didn't know that, but you got a lot of bond conditions. And if you have make contact with the victim without the proper authority, then you lose your bond and then you sit it out in jail until the trial. So get a resetting for announcement. Chastity Rashman. That's Kyle Gasper is the attorney.
Yes. Just over here. Chess. She's kind of. That's not mine. That's I don't think she has a lawyer.
You don't have a lawyer, do you, man? Come on up. 25 CR 1041. You're charged with assault on a peace officer, which carries with it up to 20 years in prison. It's very serious. Langston, this is you.
I don't believe she has an attorney yet, Your Honor.
If you, I can.
Chastity Rashman?
Not from here.
Are you Chastity
Yes,
Rashman?
sir. Chastity Rashman.
Look at it.
If you tell me, well, I can do
Well, I
that.
didn't even know what courtroom I was in today. So,
I don't mind. I mean, I'll be happy.
Well,
but I didn't get anything.
You didn't get-
Look at the
I'm not
docket.
seeing it on Odyssey either.
Look on the docket.
I'm looking at it.
It don't
but-
have me at all.
I know, but what was that thing I just gave you? That you just took?
And was it now? I don't mind. I help him.
Well, I mean, how does this get?
I have no clue.
That's so weird.
But that's not no problem. I can get with her, and if you just put me on an announcement, I can meet with her outside today, and then we can put together a plan, and I can get with Mrs.
Do you have your own lawyer?
no, I don't have a lot.
Are you able to hire one?
Not at the moment because I lost my job.
Okay, well, Mr. Adams somehow got placed on as,
It was back when she was arrested in the jail.
Because they took me twice and I didn't understand it either.
yeah,
So,
okay. Well, we're gonna put you on the list for her, okay? It's, talk to her, and this was an initial appearance, so we'll put it on in an announcement, but get with her, okay, while you were here, Austin, and she's here, so you'll talk about it. Okay. Get a resetting, man. Thank you.
Wait till you talk to me.
Yeah, from her, and then you can talk to him. Caitlin Rodriguez. Caitlin Rodriguez, please.
Ma'am, you need to kind of read that in.
Yeah, yeah, you don't get out here without putting your autograph on something.
No.
No, just stay.
It's not right there.
Caitlin Rodriguez, 25 CR 787. No answer in the courtroom. I am asking the bailiff, please call into the hall for Caitlin Danielle Rodriguez. And this is cause number 25, CR 787. Hey, Langston, bad news. This is one of yours too.
Not again.
Yeah, there it is. Look.
They didn't have me on the docket.
Oh, Your Honor.
Hey, look.
You're in a slump right here, right now. A couple of bad innings. All right, there is no answer in the courtroom for Caitlin Rodriguez, no answer in the hallway called by the bailiff. Defendant has failed to appear. A warrant shall be issued for her arrest. Her bond was in the amount of.
Has a pending warrant for her arrest in this case.
When was that issue? This resetting was issued in August.
I'll make it work.
All right. Well, they got some things they're sorting out. Let's step across the hallway again.
It's in cause number 25, DCCR 0834. You're charged with a first-degree felony offense of aggravated robbery from May 16th of 2025. And what that means is if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 25 years in prison. You have every right to reject that. I want to make sure you understand if you pled to a cap, it means you'd be leaving your punishment up to me If I follow that agreement, I can't give you more than 25. I could give you 25, I could give you less. It would all depend on the information that was brought to me at a sentencing hearing. You have an absolute right to have a jury come decide all of this. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. I also want to make sure, Mr. Nichols, is there any reason to believe that that offer would change?
No, Your Honor.
Mr. Bates, unless there is some new information that the lawyers don't know at this time, I will not accept this plea agreement after today. Do you understand?
Yes, ma'am.
All right, Mr. Bates, also, Mr. Rojas has been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him, and I can appoint another attorney who can begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, Mr. Rojas, you're released. Mr. Bates, we will appoint someone today. They should be out to the jail to see you very soon to begin preparation for trial. All right, you can go back with the bailiff. And let's see, Ryan Bryons. Look at all these rejections on my tablet. Man. No gold stars today. And this one says plea hearing, but it wasn't.
This is a plea.
Oh, it is. I just read that completely wrong. I take back the gold star.
Well, no,
Or the lack of one.
There's some rejections coming.
There's. Good morning, sir. Are you Ryan? Is it Briones?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment in each case?
He will, Your Honor.
Mr. Briones, in cause number 25, DCCR 1106, you're charged with the first-degree felony offense of aggravated robbery from July 10th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? And then in cause number 25, DCCR 1108, you are also charged with the first-degree felony offense of aggravated robbery from July 10th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they've charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've reached with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred probation in each case. There would be a $500 fine. And then we would get a pre-sentence report done, and if there were any other recommendations or conditions such as ISF, that would be up to the court, and I could impose those at sentencing. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case?
No objection.
It's admitted. Is there any evidence that Mr. Briones is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. All right, you can go back with the bailiff. I'm not going to adjust the bond just based on the nature of his age and the possibility of ISF. All right, you can go back with the bailiff.
Thank you, Your Honor.
And Eric Gibson.
Can we hold him for a little while?
Sure.
Sign one of those.
Yeah. And then Derek Green. Ready on that rejection? Derek Green, please. Good morning, sir. Are you Derek Green? And Mr. Green, in cause number 25, DCCR 1119, you're charged with the third-degree felony offense of obstruction or retaliation from June 19th of 2025. Your indictment alleges that you were previously convicted of possession of a controlled substance, a third-degree felony, June 7th of 1999, and then after that was final, you were convicted of possession of a controlled substance, a third-degree felony, January 5th of 2000, and then after those were final, you were convicted of possession of a controlled substance, a third-degree felony, January 28th of 2008. And what that means is if you're found guilty in this case, and if those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go forward on count one only for an 8-year term in prison and waive those prior counts that would make you habitual. You have every right to reject this offer. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject this offer and have your case set for trial?
Yes, ma'am.
I want to make sure you understand, Mr. Green, that after today, I will not accept this agreement. Once your case goes on the trial docket, it will either be tried to a jury or you can plead either open to the court or something different than that 8-year term. Do you understand? All right, so we'll get your case set for trial. Mr. Green, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, Mr. Rojas, you're released. And Mr. Green, we will appoint someone today. They should be out to the jail to see you very soon to begin preparation for trial.
Thank you.
You can go back with the bailiff.
It's plea rejection day in Judge West's court for sure. Let's stay in Texas, but we'll go to San Antonio and see what's going on with Judge Boyd.
And are you Ricardo Javier Reyes?
Yes, Your Honor.
All right. You entered a plea on August 12th, 2025. There was a PSI that was completed. Any objections to the PSI, state or defense?
None from the state. No, Judge.
And so that the record can be clear, the PSI report, the pre-sentence investigation. According to your plea bargain agreement, punishment is to be assessed at 2 years in the prison. There's a $1,500 fine. The state opposes your application for deferred adjudication. They're recommending community supervision. They're taking some cases in consideration. There's an affirmative finding of family violence, and there's to be no contact with the complainant. Counsel, do you wish to speak to deferred adjudication?
I do, Judge. I understand that this is probably going to be big ask for the court to allow him to be placed back on deferred. He did have a deferred. It was for a felony. He did complete it successfully. Tells me that he can do it. But understanding having that kind of a history probably does not make the court feel very comfortable. But we would still request deferred, Judge. He had, without delving into the relationship he had with Miss Walls, it was dysfunctional and toxic. It was a two-way street. I know she has very
Okay, so here's the thing.
Yes.
Don't shake your head up and down, because let me just tell you, I've read the police report. Whether a relationship is toxic or not, you chose to be in that relationship. There are several cases that are pending where you're accused of assaulting her. And you're here for an assault family household with a previous conviction, which means you've done it before because it's a previous conviction. I will tell you, counsel, I'm leaning towards giving him deferred, and let me just tell everybody why. Because if I were to follow your plea bargain agreement, if he were just on regular probation or community supervision, if he were to not complete it successfully, the most you could get would be the minimum. But with deferred adjudication, the full range of punishment is open to the court. So the question is, do you want the full range of punishment? You know yourself better than I do, better than your attorney probably does. So if you want deferred adjudication, I will give you deferred adjudication, but you're going to be on deferred adjudication for 8 years.
Thank you, Your Honor.
And do not come to me for early termination.
State would just oppose that for the record, if I may, Your Honor, given the number of cases he has against this particular victim, state doesn't feel like he would be an appropriate candidate for deferred, and that's why we're seeking that defendant be put on probation with a conviction.
I don't think he's an appropriate candidate for deferred either. However, the plea bargain you all have reached, if he were not to successfully complete probation, he's looking at a minimum of 2 years, which is the minimum sentence. If the court were to place him on deferred adjudication, he would not successfully complete it. He's looking at 10 years in the prison. So, Mr. Itoshi?
I mean, it appears as if Mr. Reyes still wants the deferred, understanding that the term is 8 years, that the court will not entertain an early termination. As far as trying to delve back into the relationship, that he'll never communicate with her again. We've talked about this. So she is, in all practical purpose, dead to him. So he's not going to go back and visit with her. And then the rest of it's up to him. I've told him that this court can be very, very strict when it comes to things like this. He now clearly understands that. And I've told him he has to walk the line regardless of what decision the court makes, because it will not end well for him if he does not. He's aware of it.
And state, I understand your position with wanting the felony conviction,
Yes.
but there still will be an affirmative finding of family violence, so it will not go away. And this can be used for enhancement purposes. Do you understand?
Yes, sir.
All right, so again, you know yourself better than I do, better than the state does. If you want, I will follow your plea bargain agreement where your underlying sentence will be 2 years. What that means is if you were unsuccessful, the most that the court will be able to sentence you to is 2 years. Or if you want, I will give you the deferred adjudication for 8 years. And if you're unsuccessful, the court could potentially sentence you up to 10 years in the prison. Which do you prefer?
I prefer deferred.
All right. Ms. Abrams, are you ready? Yeah. Court is going to sentence you to 8 years deferred adjudication.
Thank you, Your Honor.
You're welcome. There's to be regular reporting by Zoom or in person, regular random UAs. And let me see. I'm going to follow the recommendation of TAP, intensive outpatient treatment. Are you in any type of?
I'm in outpatient right now.
All right.
Yes, ma'am.
With
Camino Real. It's in Jordanton, Texas. I've been doing that already for almost 2 months.
All right. He's to continue.
That's exactly what probation recommended him to do, yes.
All right. So he's going to continue with treatment with, you say Camino Real?
Camino Real. Yes, ma'am.
And spell the last, is it ROY?
R-E-A-L.
I'm sorry?
R-E-A-L.
Ah,
It's on the first page.
all right, thank you.
Want to look at the
Yes,
sign.
please. Thank you. All right, so you're to continue intensive outpatient treatment with Camino Real. As a part of that treatment, do they have you do sober support meetings?
Yes, and also every week I have to meet with my psychiatrist and also a therapist, and it's been going great. I mean, it's very helpful.
All right. So he's to continue with that treatment. You're going to have to sign a release so that probation can make sure that you're keeping up with everything you need to keep up with there. Do you have any children?
Yes, I have a daughter.
What is her age?
She's 10.
All right, there's going to be 100 hours of community service restitution. I'm going to require parenting classes. Once he completes parenting classes, the community service hours will be deemed satisfied. There's an affirmative finding of family violence. There's to be the BIP course. There's to be no contact with Kimberly Walls. Take in consideration 2025 CR 005929 and 2025 CR 005927. There's a $1,500 fine. That will be probated. And I'm sorry, where did you say you were, what location for the treatment?
Camino Real,
No. I mean, what county?
Jordanton. Yeah.
Okay, and how far is Jardington from here?
About 30 minutes. It's Wilson County. Jordanton is Atascosa?
Atascosa.
It's Atascosa, yes.
Right, so, probation, does there need to be a transfer or no?
You don't know that.
I do,
Oh.
if it would be okay, that's where I
I
live.
was not aware of that.
No, Judge, however, I mean, he can report here however the bill visits.
All right. So is he says he wants to transfer there. All right, and you say that's Atascosa?
Yes, ma'am.
All right, so there'll be a transfer to Atascosa County. Probation, is there anything else? Thank you. There's to be proof of employment within 45 days. No employment as a home healthcare provider or with minors. Anything else, probation?
Did you want me to have a visit one time a month?
Yes, let's see. And then if they are unable to do it. So field visits one time per month. For 6 months. Is there anything else you need from the court?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. Obviously, you cannot drink alcohol, not even a drop. Number two, when I say there's to be no contact, it's exactly what it means. Do not call her. Do not send her apology letters. I know as a part of the 12-step program, you have to apologize for things that you've done. If you want to do an apology, you send it to probation. You do not send it to her. Do you understand?
Yes, Your Honor.
If you have any contact with her, that will be a violation of your probation. Do you understand?
Yes, Your Honor.
Is there anything that you do not understand about the court's instructions today?
No, Your Honor.
All right. Well, stay on track with your sobriety. Thank you for dressing appropriately for court. Good luck to you.
Your Honor, victim is present. She'd like to have victim impact statement.
All right, sure.
Which apparently we're not going to hear. Okie dokie. Let's change it up. Let's go to Lake County, Ohio. Judge Vincent Collada. See what's going on in his court.
In the state of Ohio versus Tanisha Watts, in 2 different case numbers. The first being 25 CR 226, and the second being 25 CR 1066. We are set, or the defendant is present with counsel Nicolette Tomazik, and we're set today for a change of plea hearing. On that 25 CR 226 case, it's the state's understanding the defendant is going to withdraw her previously entered plea of not guilty and enter a guilty plea to count 1, unauthorized use of a vehicle, a felony of the 5th degree. And on that second case number, the 25 CR 1066, it's the state's understanding that the defendant is again going to withdraw her previously entered plea of not guilty and enter a guilty plea to count 1, aggravated possession of drugs, a felony of the 5th degree with an attached forfeiture specification. If those pleas are forthcoming and accepted by the court, the state would then move to dismiss the balance of the indictments at the time of sentencing, and there is a joint recommendation for community control in this case. Thank you.
Thank you. Ms. Thomas, does that sound accurate?
That is all accurate, Your Honor.
Thank you. And Ms. Watts, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your plans are here this morning?
Yes.
They indicated to the court they believe it's your desire to withdraw your previously entered pleas of not guilty to the charges in these counts, and to plead guilty to 1 charge in each of the counts. The remaining counts would get dismissed pursuant to the agreement. We would defer or continue the sentencing to a later day to get some evaluations completed. Come back on a future day for sentencing where there's no agreement between the party. Oh, there is an agreement. I'm sorry. There's an agreement between the parties that community control sanctions will be recommended by each side. Is that your understanding of the discussions that took place between your lawyer and the prosecutor? Most importantly, what you want to do here this morning?
Yes.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to be assured you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you need a moment or like a moment to talk with your lawyer so you could ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Okay.
All right. Well, let's get started then. How old are you, ma'am?
44.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No, just my prescription medication.
And that was my next question. I was going to ask you, what about even prescribed medication?
Yes, just one that I take for my eye.
For what is it for?
For my eye, for ocular pressure.
Do you know the name of it or not?
Yes, acetazolamide.
I'm just going to put eye medication, right? So you took that today or last night?
Last night around 6 o'clock. It's every 12 hours.
Okay. Does that medication in any way affect your ability to understand or appreciate where you are, what's going on around you, or anything
No.
like that? Okay. Any other drugs or alcohol prescribed or otherwise?
No.
Now, you should have received, or I know you did, a copy of the indictments in each of these two cases previously. Do you remember getting those?
Yes.
You had a chance at some point to look those over?
Yes.
Now, in each of those indictments, you are charged with multiple counts. You're pleading guilty to one count in each of those cases, so I'm going to review those with you. Let's start with 25 CR 226. Again, you're charged with 2 counts. You're pleading guilty to count 1. And what's alleged here in count 1 and what you'll be admitting to is honor of between September 2nd, 2024 and September 21st of 2024 in Manor Lake County, Ohio, that you did knowingly use or operate a motor vehicle being a 2024 Ford Edge without the consent of Enterprise Rent-A-Car, who was the owner, or any other person authorized to give consent, and you removed it from the state or kept possession of it for more than 48 hours. That conduct constitutes the offense of unauthorized use of a vehicle. And with that additional finding, it's a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes.
Any questions about it?
No.
Now, there is a second count of the indictment involving the car, same car it's receiving stolen property, which is a more serious felony. That's being dismissed. Is that your understanding?
Yes.
You have any questions about that charge?
No.
Now, in case 25 CR 1066, charged with 2 counts, pleading guilty to count 1. And what's alleged in this count and what you're admitting to is on or about February 11th, 2025 in Manor Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance containing methamphetamine. That is a Schedule II controlled substance, and the amount involved did not equal or exceed the bulk amount, which makes the offense aggravated possession of drugs a felony of the 5th degree. You understand what you're charged with and pleading guilty to in regards to count 1 of this case?
Yes.
Any questions about it?
No.
Now, this charge also carries with it what we call a forfeiture specification. And what's alleged in this specification is that during the commission of the offense, you possessed or had interest in property considered to be contraband or an instrumentality. Contraband is property that's illegal just because of the nature of the property itself. An instrumentality is some type of property that there may not be anything illegal about the property in and of itself, but it's being used in an illegal manner to facilitate a crime. You can't use or possess it for that purpose. And here it's alleged that there is the methamphetamine along with another controlled substance, dexamethasone. And the whole point of this is that you just forfeit any interest or ownership you have in either of those 2 drugs. You understand? That doesn't increase any penalty you face. You just forfeit your ownership or interest in it.
Yes.
Any questions about it?
No.
Now, there's a second count of this indictment that's being dismissed pursuant to the agreement. Is that your understanding?
Yes.
Any questions about that charge?
No.
All right, well then, before I can accept your plea, I need to make sure, again, you understand the rights you're giving up by pleading guilty, and you first of all have a right to a trial. Now, a trial can be to me as a judge, or I listen to the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial is in front of 12 citizens, or would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes.
You understand by pleading guilty you're giving up your right to have a trial in both of these cases?
Yes.
Now, if we had a trial in either of these cases, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what it actually means is that it is her job, or she bears the responsibility or the obligation to prove you guilty before you could ever be found guilty. You are presumed innocent of all the charges in both of these cases, and that presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when I speak of this burden of proof, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden there is in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges I just read to you beyond any reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes.
Now, in order to do that, or at least in order to try to do that, the prosecutor would call witnesses to court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and that's called cross-examination. She could ask them anything she wanted to, within certain rules. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want. Do you understand that?
Yes.
And you further can request the court issue an order, call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to do so voluntarily. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor is not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Further understand that if we did go to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding this court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No.
You understand them all?
Yes.
Still want to plead guilty?
Yes.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor We're not gonna argue that you didn't do it or it's someone else's fault or anything like that. Do you understand
Yes.
that? Further, as a result of pleading guilty, the effect of that plea is that you'll first of all be found guilty by the court, and then you will subsequently, on a future day, another day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you're pleading guilty to a felony, 2 felonies of the 5th degree, 1 in each count. Oh, excuse me, 1 in each case. Now, a felony of the 5th degree in each of these cases is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes.
Now, since there's 2 separate cases here that are completely unrelated to each other, if the court imposes a prison term in both of these cases, I would have the option, or the authority, I should say, to run the prison terms concurrent or consecutive to each other. Concurrent means together. You serve them at the same time. Consecutive means one after the other. You serve the prison term for one case, whatever it is. It could be different, it could be the same. Serve it, then you finish that, and then serve the prison term in the next count. Do you understand the difference there?
Yes.
So with both cases combined together, there's a potential maximum prison term of 24 months or 2 years in prison. You understand that?
Yes.
Now, are you currently on probation or parole to any other courts or agencies?
No.
Do you have any other charges pending against you in any other court?
No.
If a prison term is imposed in either of these cases upon your release from prison, you could be placed on what we call post-release control, sometimes referred to as parole. And that's a period of supervision you would be on after you served and completed the prison sentence. And with each of these cases, it could be up to possibly 2 years. You understand that?
Yes.
And if you were ever on post-release control and ever violated any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
All right. Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible. Prison's not mandatory with either of these charges. You are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
Yes.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're requesting. It appears that you are. I'll look at all the information that gets presented. Then I'll make the decision I think is the right thing to do. Do you understand that?
Yes.
If you are put on probation or community control sanctions, it could be for up to a period of 5 years. And as the judge, I do have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes.
Further, if you are on probation, you're violating the conditions of your supervision. I strike that. I didn't even talk about the fines, did I? I didn't talk about the fines, did I? Yeah, let me go back. Let me go back for a second. I jumped ahead. In addition to the possible prison sentence, there's other sanctions that could be ordered. I could fine you. In each case carries a potential fine, and not required to do that, but it could fine you up to $2,500 in each case. So that's a maximum fine of $5,000. I could order that you pay court costs. I could also order that you reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes.
Further, in the case with the motor vehicle, I think it's 226, I could order restitution be paid to any victim for any economic loss any victim may have suffered. Do you understand that?
Yes.
In the drug case, there's a possible license suspension that I could order. I'm not required to, but again, I could suspend your license up to 5 years if I thought that was warranted. Do you understand that?
Yes.
And also in the drug case, as I mentioned before, any right, title, or interest you have in the contraband that was seized would be forfeited to the state of Ohio. You understand that? Okay. All right, now let me pick up where I was. As I said, I mentioned the possible prison sentences you face. Prison's not required, though you're eligible for probation. Just because you're eligible doesn't mean you get probation automatically. I consider that, and I'll make the decision I think is warranted. You understand that?
Yes.
Now, if you are put on probation, it could be for up to 5 years, and if the judge has the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months, the condition of probation. You understand that?
Yes.
Further, if you are on probation and you were violating those conditions, we would have a hearing here in court to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I can impose or order more restrictive sanctions, which could include an order that you serve time in jail, or I could terminate your probation and send you to prison. If I did that at that point, again, it could be 6 to 12 months on each case. I can run those terms consecutive, so possibly 24 months in prison with both cases, and that would be, or could be consecutive to any other prison sentence you may be serving for some other new case. If you picked up a new case or that you're being sentenced for, do you understand that?
Yes.
Lastly, when we do come back here, you're going to have the right, when we come back for sentencing, you're going to have the right on that day to say anything you want. Anything you'd like me to know or consider. Your lawyer could speak on your behalf. She can recommend a sentence to the court. The prosecutor can also recommend a sentence to the court. Do you understand that?
Yes.
Now, do you understand that whatever the lawyers say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I'm not required or obligated to follow that if I didn't think that's what should be done. Do you understand that?
Yes.
All right, well, do you have any questions at all about these potential penalties you face by pleading guilty?
No.
You understand all the possible consequences?
Yes.
Do you still want to plead guilty?
Yes.
Have you had enough time to discuss this case with your lawyer and have her review the reports with you, discuss the issues, and answer any questions you may have?
Yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has she or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering your guilty plea freely and voluntarily?
Yes.
All right, then, Ms. Watts, any questions for me at this point regarding anything we've talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all?
No.
Do you need any more time to talk to your lawyer before we go forward with your actual plea of guilty?
No.
Do you need it? Do you need any more time to talk with Ms. Tomazik?
No.
Okay, just check and make sure. Because we're going to go to the actual plea now then. So what's going to happen is the prosecutor is going to explain for me what she believes the facts would show if we had a trial. And for each case, we'll do one case at a time. I want you to listen to her because then I'm going to have some questions for you about that, all right?
Okay.
So let's start with the case involving the motor vehicle.
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on or between September 2nd, 2024 and September 21st, 2024, the defendant did knowingly use or operate a 2024 Ford Edge, and that car belonged to the Enterprise Rent-A-Car in Menor Lake County, Ohio. The defendant rented it from that location, and she had it in her possession for more than 48 hours without their approval.
Ms. Watts, were you able to hear what the prosecutor had to say regarding what she believes the facts would show if we had a trial?
Yes.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes.
Very well, then regarding count 1, charging you with unauthorized use of a motor vehicle, a felony of the 5th degree, what is your plea to that count?
Guilty. Guilty.
All right, we're going to proceed now to the next case, 25 CR 1066. Ms. Bell?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on February 11th, 2025, the Menor Police Department responded to the Gordon Food Service in Menor Lake County, Ohio for a warrant pickup for the defendant, Tanisha Watts. Pursuant to that arrest, her purse was searched and suspected methamphetamine was found. That was sent to Lake County Crime Lab, confirmed to be methamphetamine, a Schedule II drug. And for purposes of the forfeiture, dexamethasone was also found a dangerous drug.
And is that the warrant for this case, the car case?
Yes, Your Honor.
Ms. Watts, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show in this particular case if we had a trial?
Yes.
And what, if any, thoughts do you have about that? Is it accurate what she said? Did you do what she said?
Yes.
Very well then, regarding count one, charging with aggravated possession of drugs, drugs being methamphetamine, a Schedule II controlled substance. With that forfeiture specification, what is your plea to that?
Guilty.
I just noticed on the change of plea form, it says $5,000 fine.
I think I was thinking ahead and adding the two cases together. Yeah, but I noticed that. I apologize.
So what I'm changing here, Ms. Swanson, it's consistent with what I told you. Each case has a maximum fine of $2,500. Again, it's not a mandatory fine.
Okay.
The paperwork that on 1066 involving the drugs says it's up to a $5,000 fine. That's not accurate. It's up to a $2,500 fine.
Okay.
The total with both cases would be $5,000. You understand that?
I do. Yes.
So I just made that change on the form.
Okay.
All right, well, speaking of the form that I have in my possession, these two documents, they're each called written pleas of guilty and judgment entries, which explain everything I just went over with you. There's one for each case. Before I can accept your plea in either of these cases, I need to make sure you understand what these documents say and that you sign them here in open court. My understanding is before I came out here, you had a chance to review these documents with Ms. Tomasic. Is that correct?
Yes.
Ms. Tomasic, is that accurate? Did you read these over with your client, review them with her, answer her questions?
Yes, Your Honor.
Did she indicate an understanding of them to you?
Yes, she did, Your Honor.
Is that correct, Ms. Watts?
Yes.
Do you have any questions for me about what they say?
No.
It also appears you signed them both. Did you sign them?
Yes.
And Ms. Tomasic, you witnessed that?
Yes, Your Honor.
And Ms. Value as well?
I did, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's pleas. And in case 25 CR, excuse me, 266, I'll find the defendant guilty of count one unauthorized, 226, I'm sorry. I'll find the defendant guilty of unauthorized use of a vehicle, a felony of the 5th degree, violation of 2913.03B. Count two will get dismissed at sentencing. In case 25 CR 1066, I'll accept the defendant's plea and find her guilty of count one, aggravated possession of drugs, a felony of the 5th degree, along with the forfeiture specification. It's a violation of 2925.11. Count two will get dismissed at sentencing in that case as well. Sentencing, however, in each case will be deferred. I'm going to order in 226, pre-sentence investigation, victim impact statement. In case 25 CR 1066, I'm going to order a pre-sentence investigation and drug and alcohol evaluation. Both cases I'll continue bond at defendant's own recognizance. So what that means, as far as bond goes, in each case I'm continuing the OR bonds. There's nothing more you need to do about that, except you need to appear at the probation department when required, and more importantly in terms of that bond, you need to appear, well not more importantly, but you need to appear for your sentencing hearing. And if you didn't, it would be a separate felony you could be prosecuted for. That's why I say it's more important. When's the sentencing stand? November 24th at 1:15. So, that's the next court hearing they get to appear for. You understand that?
Yes.
Now, prior to that, you're going to have to show up at the probation department so they can conduct some interviews with you, so they can complete these reports I've ordered.
Okay.
The purpose of those reports is so I can learn more about you. The way they get the information they need to prepare the reports is that they're going to conduct some interviews with you. They're going to, if you answer some questions, it's important when you meet with them, speak with them, that you're open and honest with them, and answering their questions and providing whatever information is requested, because they're going to check and verify everything you tell them. If they learn you're misleading them in any way, they'll let me know that, and I'll consider that sentencing. You understand that?
Yes.
Those reports also have to be completed before this court can even consider probation as an option. Without a report, a pre-sentence report, I don't have the authority to consider probation. So in order for those reports to be completed, the interview with you has to take place. So it's important that you show up on time, when scheduled at the probation department for that interview. Because if you don't do that, then they can't complete the report. Without a report, again, I can't consider probation. And I won't continue the sentencing to a later day to get the interview done because it wasn't completed initially because you didn't show up or cooperate. You understand that?
Yes.
Lastly, one of the conditions of your bond, again, is that you don't use any drugs. You have to submit urine screens if requested. They must be negative. A positive screen will result in your bond being revoked and a warrant being issued. Do you understand that?
Yes.
All right. So you're going to leave here now. You're going to go to the probation department, fill out some initial paperwork, and get your dates to come back for that interview. So make sure you go there when you leave here, okay?
Okay.
All right.
Thank you.
You're welcome, Ms. Bell. Anything else for the record?
Nothing further, Your Honor. Thank you.
Ms. Tomazik?
Nothing further, Your Honor.
Thank you.
Okie dokie, friends. Let's head back to Texas. Judge Stevens again.
You have indeed hired Mr. Burbank. Okay, well, he's late for work. You've already paid him? Yes. Okay, just have a seat then. We'll wait for him. And Tiffany Butler was reset.
That's correct. She hired an attorney.
I'm sorry?
She hired an attorney.
That's great. That's a great thing. And that's important. Independence is good. Who was it? Do you know who's been hired?
I was just notified that she had hired someone.
Hey, Langston,
Oh, yes, sir.
Yamuel Burgos.
He's
We're,
good.
we're on the 9:30 docket. I'm gonna need the 9:30 finals.
Wow. What?
You want half? All of it.
Well, let's let them sort out who's coming up. In the meantime, let's go to Judge Boyd.
Have you had a chance to review the PSI report?
Yes, ma'am.
All right, do you have any objections to the court reviewing it?
No, ma'am.
Just give me 2 seconds. I want to see what the TAP evaluation says. Bashan? Bashan, do you know the TAP evaluation on June Bright? No, it's the TAP isn't on here. I have everything except the TAP. Thank you. Welcome. And you've had a chance to review the TAP?
Yes, ma'am. And I reviewed it with Ms. Bright.
Thank you. All right, the court is calling 2025 CR 0022831, State versus Jim Bright. Could I have parties announced for the record?
Ashley Morgan on behalf of Ms. Bright.
And are you Jim Bright?
Yes, ma'am.
All right, I'm gonna need you to speak up so the court reporter can hear.
Yes, ma'am.
So you entered a plea in this case, and according to the plea bargain agreement, punishment is to be assessed at 6 years in the prison. The state is recommending community supervision. Have both parties had a chance to review the PSI report and the TAP evaluation?
Yes, ma'am.
Yes, Your Honor. Okay. Sorry. No problem. Any objections?
There's no objection from the defense.
All right. Is there anything, state you wish to put on the record?
No, Your Honor, I believe that we had recommended community supervision in this case, and I believe it was just reset for her to receive her evaluation. So I don't have anything additional to add at this time.
All right, state, you may be excused. So, Ms. Bright, how are you maintaining your sobriety?
I work
Mhm.
and I crafting, I do arts and crafts. I make different type of jars, different decorations.
Okay.
Tip jars for like businesses and stuff.
I've
And
never been good at crafting. I try, but
it's relaxing. It's
Oh,
very
awesome.
relaxing. So I've been doing that for about a year. I've let some people see them and they really like them. So I'm gonna launch that business probably in the beginning of January. Where, make my own custom tip jars and take them around and vend in different events.
oh, that is
As a
awesome.
vendor. Yes, ma'am.
The holidays are coming up. You may want to try to get into the
Yes, ma'am.
holiday scene.
I've made some with Halloween decorations on them already. I made some with Christmas decorations. So every season I have a tip jar for that.
You should have brought one so I could see it,
Yes, ma'am.
but I'm sure they're great. All right. Is there anything you wish to say?
Yep, Judge, we're just asking that you follow the agreement, especially the PSI. I think they did an accurate evaluation of my experience with Miss Wright.
All right. Are you doing any type of, oh, I'm sorry, go ahead.
I was just gonna talk to you about the jail time, the 10 days condition.
Oh, okay. Well, before we get to that, so, are you doing any sober support meetings or anything of that nature?
I haven't started any support group meetings, but I'm looking forward to, and I want to meet and talk with some other people, and then as well as do therapy in the VA through the VA and with veterans. So
Okay.
I'm going to sign up for that program.
All right. So I tell you what I'm going to do. I had no idea she was a veteran. All right, everyone, please whisper. Probation can't hear. There's something wrong with the mics. Thank you. All right, so what I'm going to do is I will sentence her, and then we can see if Veterans Treatment Court will take her. State, if Veterans Treatment Court will take her, would y'all have any objections to doing a motion for new trial? For placement in Veterans Treatment Court, if they will accept her. To health court.
Okay,
You're
yeah,
right.
because she's already on community supervision, but because this offense is not eligible for deferred, so.
Yes. All right. So then I'll do a referral for you for Veterans Treatment Court. So the conditions I'm going to give you, if you're accepted into Veterans Treatment Court, they will give you different conditions because you will no longer be under the umbrella of probation here. Do you understand? All right. So that may be a good placement for her. All right. Thank you. All right. So this is what the court is going to do. The court is going to sentence you, as previously stated, the court is finding you guilty. The court will sentence you to 6 years in the prison, suspended and probated for 3 years. There's a $2,000 fine that will be probated. Ignition interlock. You all didn't say if you wanted it half term.
Half term, yes, ma'am, I think that's for the agreement.
All right. It's not listed.
Okay.
Yeah. So I tell you what, probation, I'm gonna do ignition interlock for full term. However, at the half term, you can come if she's doing well. More likely than not, I will grant the removal.
Okay.
So ignition interlock full term. 2-year license suspension. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. Field visits 1 time per month for 6 months. 200 hours of community service restitution based upon your service. What I will do, I'm going to order 60 sober support meetings in 60 days. For every sober support meeting you do, an hour of community service will be waived. There's 10 days in the Bexar County Jail as a condition of probation. You can either do the 10 days in jail, but because there are health issues at the jail, overcrowding at the jail, I can either give you GPS, ask that the fees be waived. You'll do it for 10 days, and that will be full GPS. Or if she has employment then it will be 30 days and it'll be partial for employment. So if she wants it on just for 10 days, that will be full GPS.
She does work, Judge, so she would want it for the 30 days with fees waived if possible.
All right, 30 days GPS in lieu of the 10 days in the Bear County Jail. Waive fees. It will be partial GPS for employment. DWI education course, victim impact panel live.
And do you want the education or the intervention?
Usually usually probation will tell me if they want education or intervention. So, Ms. Abrams? It can be DWI education or either the intervention course, and I'll let probation decide which is more appropriate because. All right. Because sometimes the PSI report doesn't give me insight. All right. All right. Is there anything else, probation? Is there anything else you need from the court to be successful?
No.
All right. And I'm sorry, probation, we'll do a referral to Veterans Treatment Court. Thank you. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. When people drink and drive, it's not good, right? Especially when they're intoxicated. This is what I discovered. Usually, if there is an accident, the person who is intoxicated, they just walk away just fine. It's their passengers and other people who are just trying to get from point A to point B.
Yes.
If people want to drink, it's like make plans, have a designated driver. And designated drivers love that. I loved it because I would always get free meals. All right. So you're going to have to make sure that you stay on top of everything. All right.
Yes, ma'am. And
Mhm.
for me, I just want to interject. One of the mistakes I made is I fell in love with a narcissist instead of staying in love with myself.
Mhm.
And so from the time of the sentencing up until now, I've done a lot of self-reflecting and self-discovery and rediscovering myself and falling back in love with myself.
Oh, I'm so proud of you for doing it. A lot of people don't do that. They go from relationship to relationship, but you got to figure out who you are.
Yes.
And now that you know who you are, guess what? If you get into another relationship, you got to already know what your no-goes are.
Yes, ma'am.
And then don't cross the line.
Yes.
All right. Good luck to you. Okay. You're welcome.
Judge, I don't know if you meant to hand that to me.
Oh.
Already given me.
You're
welcome.
Okay, friends, we're going to move on to another court, but before we do, let's talk about the sponsor for today's show. You know it, you love it. It's one of the things we talk about so much here, of course. Michael Groff. He's the sponsor today. Seriously, we have a lot of new people out there, so you may or may not know about Michael, but what I'd like you to do is go subscribe to his channel. Michael is the best. He's always active in the chats. He is active on Sidebar with us Tuesdays and Thursday evenings as a panel member. He'll be there tonight. He is the official guest host of TCF, and in fact, starting the 27th, he will be in the big chair for 2 weeks while I'm gone for my daughter's wedding. As Bailey just put it in the chat, Michael Groff is the man. So do me a favor, if you're not already subscribed to Michael, please go subscribe to him now. Barbara just dropped a link in the chat. He's very much worth it, even if you're not from Arizona. He mostly covers Arizona weather, but he has the voice that soothes the people. It's lovely. He's much better at this than I am. He deserves your full attention, and most importantly, support the people who support the channel. So go check him out, please. Let's go back to Judge Stevens. He has another contestant.
25 CR 713 Yamuel Burgos. That's you? What is that name derivation? Is it Burgos. I'm not familiar. I've never known anybody Burgos. What is it? European name or something? What do you think? No? The family name is Burgos. But Yamuel, that's interesting. Where'd that come from? That's Bible? Is that a Bible name? No? Okay. Samuel is. I thought Yamuel would be close. Right. Okay, so
Judge, I just want to.
Langston Adams is your attorney?
Right. Judge, I
Okay.
just want to put for the record, I have met with him on this case, gave him discovery, gave him police reports. The offer is deferred adjudication. I let him know that it would be a deferred $500 fine, which doesn't be on your record. He's adamant for saying that he has nothing to do with this. They got the wrong guy. He is, what you tell me? You say you didn't have nothing to do with this? So that's what he told me.
Okay. The victim in this case, do you know this person? The victim in this indictment? He went over the indictment with you, right?
I gave him. He got that.
The name is in there. I'm not going to say the name because I don't like victims' names being called out. But this states you discharged a firearm at a person and property. It looks like at somebody's home on Maddox Street. You don't know anything about this? You don't know this person who lives there? Okay.
He's saying, he told me that they got the wrong guy. He has nothing to do with the case. And that's the name judge is referring to. You don't have to say it, but that's the name of the indictment. Did you see that name? Yes, sir. He's saying that he has nothing to do with it. Not just keep that with you in case he actually came. That they got the wrong guy. So, but like I said, I did let him know about Mr. Laird's offer of the deferred adjudication. $500 fine was the offer. But again, he's telling me that they got the wrong guy. He has nothing to do with this, right? So I just want to make sure I quoted you correctly.
I'm looking at the probable cause affidavit, which states that surveillance video confirms you arrived at the scene of a shooting in the vehicle. You exited the vehicle, walked toward the area where the shooting occurred. Immediately after, you returned to the vehicle with your injured brother, the female, and two other individuals, all armed with rifles. Then you drive the vehicle away with the others as BPD, the Beaumont Police Patrol units arrived. And all of this is clearly shown on video. That's what this says. Okay, we'll set it for trial.
Yes, sir.
It's a third-degree felony, which carries with it up to 10 years in prison. Just for your information. Jawan Kolar was reset. I've got Jasmine Dudley next.
Come on up, Mr. Dudley. Judge, when we were into the last on this is Dudley.
Jasmine Dudley, that's you?
Yes. The pawn had evaluated, well, was supposed to evaluate her, and he came out with his report, I think early September. I could be wrong. I got a copy of it. This is it right here.
Judge.
You got a warrant for your arrest. You're not going anywhere. And we got to process that first before we get to this.
No, he just can't, well, not just, he found her competent. So in light of her new case and then what you're looking at right there, let me see what I can do to try to work that one out.
Mm-hmm.
When we here last, we was looking on that.
Okay.
So I guess in light of this new case, I'm resetting. I can get Judge. You gonna point me?
Let me make sure I've got a copy of this in the phone.
All right, while they seek the next contestant, we'll go across the hall to Judge West.
Jacoby Lawrence.
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Lawrence, in cause number 25 DCCR 1134, the state is elected to proceed on count one only. It alleges that you committed the third-degree felony offense of harassment of a public servant from June 12th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am, I did.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Lawrence is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of harassment of a public servant. Sentence you in accordance with your agreement to a term of 7 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm.
Yes.
If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.
Yes.
All right, good luck to you, sir. You can go back with the bailiff.
You have a credit.
Thank you, sir.
Thank you, Your Honor. 2 more I'm working on.
Okay, thank you.
All right, let's go to Louisiana. Haven't been there yet this week, as I recall. Let's see what's going on with the board.
Date is October the 14th, 2025. The time is 9:29. My name is Carolyn Stapleton. I will serve as the chairman today. My colleagues on the panel are joining us by Zoom, Ms. Jerry Ledoux and Mr. Danny Barra. Is there any staff in there that would like to introduce themselves for the record?
Ms. Lawrence?
Okay. Mr. Smith, I need you to introduce yourself for the record with your name and DOC number, please.
My name is Denard Smith, DOC number 120613.
Okay. Do you have a questionnaire in front of you that you or ask questions like, can you read and write, stuff like that? And you would have signed.
I can do a little read.
Uh-huh. So you have that questionnaire in front of you?
Yes, ma'am.
Okay. Well, according to the questionnaire and the answers that you gave, you're not eligible for appointed counsel. Did you want to hire counsel? Because we don't have any counsel here for you. Are you okay with proceeding?
Yes, ma'am.
Okay, thank you. So the lead person in your case today is myself, Ms. Stapleton. So I'm going to read your rule violations, and you're going to have the opportunity to plead guilty or not guilty with a statement. Okay? Now that you violated rule number 4, on or around 6/27/2025, you engaged in criminal activity when you committed the crime of accessing a device for fraud and domestic abuse battery involving strangulation, which led to your arrest by the New Orleans Police Department on the aforementioned charge on 8/26/2025. Later, the charges were refused by the DA's office. What do you plead?
Not guilty.
Okay. And number 10, you violated this condition as evidenced by your failure to make payments towards your supervision fees since 5/31/2018 in the amount set by the Louisiana Department of Corrections pursuant to the Louisiana revised statute, which has caused an arrearage of $8,475. How do you plead?
Plead not guilty with the state.
Okay. Okay, well, go ahead with, did you want to make a statement for number 4?
What's number 4?
Number 4 was using, the phone to access this person's bank account and, you stole money. Says, the victim indicated that the offender had stolen money from her Chime bank account and the multiple pictures with the offender's name listed as making the transactions without consent. And then the incident report pertaining to the domestic abuse battery. And they asked the 5 risk factor questions involving the victim, and she said yes. So now she took pictures. They had shots of you, of your name and everything.
Yeah,
Using
but
that.
I haven't had a phone since May. I don't even know how my phone had been off since May. So I don't even know how that even come up. And I don't even know how to use a phone like that, man.
Well, you said that one time, then another time you said she showed you how.
Did I say that?
No. Go figure.
She said, the officer showed me the phone saying this. She said she seen this on the phone. But I don't even know how that happened, man. Because I don't even know how to really use the phones like that. And I don't know how to get her phone. They say I had her phone.
Yeah.
I don't remember having it.
Really?
Yes, ma'am. So they confused me with that. I don't understand.
Okay, well, what about the domestic abuse battery involving strangulation? Ms. Tillman stated that while she was laying on her bed in her bedroom, Mr. Smith then straddled her by sitting on top of her stomach and the midsection and placed both hands around the front area of her neck and began squeezing and applying pressure. Ms. Tillman stated that she did not lose consciousness. However, she did have difficulty breathing. Ms. Tillman said that Mr. Smith stopped choking her. Then she grabbed her phone and called 911. And then the victim was asked the 5 risk questions. And she answered with, do you think he would seriously injure or kill you or your children or someone else close to you? And what makes you think so? The victim answered yes. How frequently does he intimidate, threaten, assault you? Is it changing better or worse? The victim answered, for the last couple of weeks. Describe a time you were most frightened or injured by him. The victim answered, the other day. Number 4, have you ever been threatened or intimidated by your abuser for seeking help or attempting to get help from law enforcement or the courts or others? If so, who threatened you and when was the threat made? Describe the nature and was there a weapon used? And the victim said today. Does he or she possess firearms? And has he used them to threaten or control you or other people? What is the type and description and location? And the victim answered no. So of the 5 questions, she answered yes.
I don't even know this victim. I never even heard of that name. I never been approached by no police or nothing. I've been living at the same address since I've been home. And I don't even know who this victim is. I never heard of that name.
You don't know Miss Tillman?
No, I don't even know Miss Tillman. I don't even know how they got my name. I haven't been in an altercation since I've been home.
Okay, listen, this is what it says that you didn't remember. Mr. Smith stated, Miss Clayton. Miss Clayton. You know Miss Clayton?
Miss Clayton, what's the name? Clayton.
Okay, Miss Clayton allowed him to use her Chime banking account while she was in detox at the Odessa house. Mr. Smith stated when she was released from detox, he came to the house demanding money. He took out of her account, to which he said he would return the money, but only had approximately $60 on him. Mr. Smith stated he did not return any of the 60 he had to Miss Clayton. He just stated he would repay her later. The officer advised Ms. Smith of the amount of money that was removed from the transfer from Ms. Clayton's account, to which he responded that he was going to pay her back. So you told the officer you were going to pay her back too. And then you said you knew how to use the phone.
Yeah, officer came to my house early that morning to me and my mom.
Okay.
He came with Onisha Clay. And she said I had took some money from her. So I said, how could I take some money from her? And then she said, okay, you owe me this. I said, okay, if I get a little change, I'm gonna pay you money because I don't want no trouble. I'm not trying to get in. I don't know what you're talking about, what you did with the phones or whatever. I don't know. But I was willing to pay her back. Whatever she said, I said, me and my mother to keep trouble down. But some kind of way they come up with a warrant talking about some kind of body. And because he was gonna write me a summons to pay her. And me and my mother was gonna pay her. Even though we didn't know what she was talking about by our phone, because I never had no chime card or nothing. But we just didn't want no trouble. I didn't want to go through this because my mom is 89 years old. She on a dialysis machine and a breathing machine, and I'm taking care of a 9-year-old son. I didn't need no trouble to be going through what I'm going through. I am 60 years old.
Well, you got the complaints are against you from two separate women, Miss Clayton about the phone and the theft, and then doing that he ran outstanding warrants, and that's when the name came up from Miss Tillman that involved a domestic abuse, battery, or strangulation. Two separate incidents.
I don't even know that lady. I don't even know nobody of that name.
Okay. Does my colleagues have any questions?
So, from what I can understand, the charges were dropped in this case, and the victim has not been able to be located by our victim's coordinator. Mr. Smith, in reading the narrative, you've had a very unstable living situation, having problems with girlfriends and things like that.
Well, I haven't been living with no one since. I only live with one lady, and I got out of her because of the situation like it. And I've been living with my mother, taking care of my mother and my son with the little financial I get. I haven't been getting no confused with nobody. I can't afford that. I have a mother depending on me and a son depending on me. I refuse to come out the house. Only time I come out the house if they call me to go do a little work. I have no problem with nobody out there. I refuse to argue with women or with anybody because I know my situation and my mother and my son need. And I haven't been this lady I haven't been around no lady to do all that. Okay. I haven't.
Okay.
I don't even know who this lady is. Now, when Miss Clayton came up, whatever she was talking about, we was trying to solve it right because I don't want no problem with nobody. I've been out of jail for a minute, and I do not want to do this anymore. I am too old for it, and I have two people depending on me. So I was willing to give her a thing, but the warrant that came up, we was gonna pay her a little, whatever she said whatever happened with the phone, what I don't know, because I really don't know how to work the phone. And that was that. But then this warrant came up, and I don't even know who this lady is. Never been around, never had no complications with any woman out there. You know, the last lady I was living with, my parole officer come help me move. And I haven't been around that lady in a minute. I haven't seen her, don't go nowhere or nothing.
Okay.
I don't know how I got caught up.
I only see one victim, Onice Clayton, okay? I'm just telling you that, yeah, you've been at Anunction Street since 23, it looks like, with your mama.
Right, that's ma'am.
Yeah, I don't have anything else to add.
Mr. Byron? Do you have any questions?
No questions.
How you doing, sir?
Let me ask you something. You're $8,475 in arrears, and you haven't made any payment since 2018. So what's going on?
I've been having jobs, you know, that I was working for a temp, every in and blue and out. They'll call me to work one day. I might work 3 days out of a month because they claim business was slow, you know, and the little change I had to try to help my mother feed me and my son. And, you know, I wasn't making the money to really do nothing. I was barely surviving with the little money. When I go out, I might cut a little grass for the neighbors or, you know, go to stores for neighbors to keep things on the table for us. I wasn't making no money. They wasn't keeping me on a job. The temps would work me for 2 weeks, work me for 2 days out of 2 weeks. And time I get the check, I owe that all out.
Well, let me ask you, what did your office?
And I just had got a job. I got a 5-day job right before I got in, like a week before I got in. I only worked it like 3 days. And they brought me to jail.
What did your officer say about this? I mean, were you seeing your officer regularly, parole officer?
Yeah, I was explaining it to him. He was coming seeing me by my mother. And the job I had before, I had just seen him before I came here on the job. I said, well, they say they're gonna try to keep me here for 5 days after start doing something. He said, well, then no, just keep doing what you're doing and continue to, you know, stay in touch with me. I haven't had no problem with my parole officers. They was all, you know, come see me, I'd see them. And they could always tell you I was always at my mother's house.
Your
financial problem was all.
You're a 4th class felon. And it involved attempted 2nd-degree murder. Now, it was a long time ago, but it was a crime of violence. And a firearm with a convicted felon.
That's what I was in jail for.
Can we go into executive session, please?
Can I get a second?
Can we get a second?
I'll second.
Goodenough,
Yes.
Byron,
Yes.
Yes.
Okie dokie, we'll come back to them after they're done with their executive session. In the meantime, let's go to Judge West.
Good morning. Are you Leonard Guillory? And Mr. Guillory, in cause number 22-40982, on probation for unlawful possession of a firearm by a felon, that probation started last June of 2024. It was a 7-year deferred probation. Motion to revoke that unadjudicated probation has been filed. Looks like the primary 2 allegations are, 1, that you have allegedly committed the offense of aggravated assault with a deadly weapon, June 19th of 2025, and also evading arrest or detention with a vehicle on that same date. The evading, has it not been filed or indicted? Okay.
Was it with a vehicle?
Yeah, it was with a vehicle. That's what, at least what the administrative hearing says, but
I
let
don't
me.
know that it was with a vehicle.
I haven't seen anything about it evading.
I think
It was only the.
my recollection was that it was evading on foot. I'm happy to explore it. Check.
That's okay, let me look at this as well. And so I'm going to take judicial notice of the court's file in each case. The new alleged offense of aggravated assault has been indicted in cause number 25 DCCR 0902. There's a $200,000 bond set in that case, and there's no bond in the motion to adjudicate. Mr. Lewis has filed motions in each of those cases asking, one, that I set a bond in the motion and that I reduce that bond. In the new allegation, I'm printing out real quick the PC. I'm going to take judicial notice of that. Give me just a second to review it as well. Mr. Coleman has filed a response, reply to those motions to reduce, and I have reviewed that as well. Give me just a second. It was on foot, yeah.
That's what I thought, Judge. It allegedly was
Started on a bicycle.
Yeah, I don't know where they get the vehicle from.
Yeah, they wrote it wrong on the PC even. That's where it came from. All right, Mr. Lewis, do you wish to call your client?
No, ma'am. Judge, this is argument.
Okay, go ahead.
Judge, as far as with these motions, the motion to set bond, motion to adjudicate, of course, majority of this does deal with this new allegation. As far as the other conditions of probation Mr. Guillory had, it seems that he was doing well with that. He technically was not working at the time of the offense. He had basically a reduced workload. It was a layoff, but they have been called back to come back to work. He's trying to be able to bond out so he can get back to work, possibly even hire his own attorney, or at least be able to take care of his bills and things like that while we go through this process of taking care of this case. So he definitely would like that opportunity, at least by having a bond set on it with the MTRP. As far as the new case with the ag assault, understandably, it is will be considered a serious offense. We are asking for a reduction there, maybe in incorporating some bond conditions that may secure any of the court's concerns with any public or private safety for the complainant witness or the general public while we're dealing with this, which could include, of course, GPS monitoring with a curfew would allow him to be able to go work and be back home to at least be able to take care of these things. With his job, he would be able to afford the monitoring and GPS monitor. He does have some support, family support. His wife is here today and has been here each time before she would come to court. And so that's what we ask for, Judge. Just, if they can get a bond that is a little more reasonable than 200,000, a bond that high. A lot of bonds from the courts, a lot of them won't even touch that amount.
So what is the status of the burglary of a vehicle in Hardin County from June 8th of this year? That's an allegation in the motion as well.
As far as I know, it hasn't been accepted or been going to court on that. My understanding. So the main issues that we were dealing with, of course, is what was here.
Well, that's obviously that one is also important to me because that would be another felony allegation while he's on this probation. Let me see if the administrative hearing has any information on that. So when the administrative hearings are scanned in, I've noticed that some of them, it'll say see attached narrative or PC or something, and those are not always scanned in.
Are you looking at the court copy? It'll say court copy.
Okay, so the court copy should
Court
have
copy,
it.
'cause, it's not public.
Gotcha.
I'm sorry, Judge.
No, that's perfect. That's what I needed. Give me a second. I'm gonna print this out because this is. Mine.
Oh, I'm sorry.
So, for the record, I'm taking judicial notice again of all of the court's file attached to the administrative hearing, which was dated June 16th, 2025, which is previous to a second one that was filed with regard to the new aggravated assault case. This one includes violation that he allegedly committed the offense of burglary of vehicle in Hardin County and failed to report his arrest to his probation officer, and then GED, community service, and some things like that. Attached to it is the narrative from the Hardin County officer. Let me read that, and I'll give you both an opportunity if you would like. So this is allegedly a neighbor where the allegation is that Mr. Guillory got in their car, tried to start it and leave, that they confronted him, that he got out, walking up and down the driveway between the trailers, quote, freaking out, striking the trailers in his own vehicle. The officer also noticed kind of some erratic behavior, felt like he was under the influence of some type of intoxicant, which he denied, but it sounds like there was something going on.
And Judge, if I may, speaking with him, he said this was an episode where he was under some type of psychosis, dealing with mental health, and checked himself in for treatment shortly after.
All right, so obviously I need that information because I don't feel like if that's going on, that it would be in the best interest of our community to have a bond at this time. If there's something going on, then potentially we need to have some type of evaluation done ourselves to find out what that is and get that information to me. Based on all of the allegations in the motion, as alleged, the burglary of a vehicle, the new aggravated assault with a deadly weapon, and the fact that he's already on probation for unlawful possession of a firearm by a felon, which means he's already a felon in that burglary of a habitation case, I believe. That was a conviction. I'm going to find, based on all of that information, under 17.15, as well as the Constitution, that I can deny bond in the appropriate circumstances. And at this time, in cause number 22-40982, I am going to deny setting a bond in that case. And I'm going to deny the request to reduce the bond in cause number 25 DCCR 0902. And if you will get any information gathered together with regard to any mental issues, obviously that could go into play once we get to whatever point we do on what I'm going to do with the probation in the new case, and potentially for Mr. Coleman as well. If you feel like there's an issue with competency, let me know. It doesn't sound like that's the issue, but if so, just let me know. We'll get someone out there to see him as quickly as possible.
No problem.
All right, you can go back with the bailiff.
All right, let's go back to Louisiana and get that hearing finished up.
Okay. All right, Mr. Smith, I'm going to make a recommendation that, that you pay restitution to Miss Clayton in the amount that it listed of $581.24 in lieu of revocation. In lieu of revocation, and then you have no contact with either one. Are these two separate ladies or the same lady with different names? Whatever it may be, because it does say Tillman/Clayton. Leave her alone. And secondly, that you attend a domestic violence offender program. A lot of times it's shortened to DVOP. So you have to attend that because there was the allegation of abuse with strangulation. She had difficulty breathing. I know that that is one of the symptoms of somebody that has been choked. And so you will have to attend that class. That's my vote. Ms. Ledoux.
Yes, in lieu of revocation, charges were dismissed. My vote is to, in lieu of revocation, for you to pay restitution, as indicated by the chair, that you have absolutely no contact with the victim of this crime, and that you take some domestic abuse classes. You've gotten a break today with the two of us, that's for sure. Okay?
Hey, Mr. Barra, what is your vote?
I'm going to concur with you two for the same reasons, with the same conditions.
Okay, thank you very much. All right, so today the decision is not to revoke you, and in lieu of a revocation, you heard that you were to pay restitution to your victim. You're to have no further contact with the victim, and you are to attend a domestic violence offender program. Do you understand that?
Yes, ma'am.
Okay, thank you very much. This concludes our business review at 9:57. And we will sign off from the Orleans Parish Prison.
Approved?
That is not how I thought that was going to go down. But okay. Good for him, I suppose. Let's go back to Judge Stevens. Let's do that.
25 CR 780 is called. You are Desmond Jerome Papillon Jr. Correct. And you are here with Mr. Adams, your attorney, and the state's attorney. I need a pen. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about May 17th, 2025 in Jefferson County, Texas, you committed the state jail felony of unauthorized use of a motor. You committed the state jail felony of unauthorized use of a motor vehicle. Do you understand what you were charged with? If convicted, you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand? Okay, an agreement's been reached in your case. What will it be? I'm waiting on the pads.
Yes, 5 years deferred, $500 fine. 5 years deferred for $500 fine.
Apparently, there's an agreement that's been reached where you're going to be pleading guilty here and placed on deferred or unadjudicated probation for 5 years. Any restitution?
No, Your Honor, the vehicle.
Fine $500. There will be terms and conditions of probation which are normal and customary for this type of offense. Is that your understanding of the plan? Yes. You have to speak up so she can hear. She has to put everything down. Okay. If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this? Guilty or not guilty?
Guilty.
I can't hear you and I'm right here. Okay. Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. I show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct?
Oh, you already signed it. He's asking me, this is your signature. Oh, yes.
Okay. State's Exhibit 1 is tendered into evidence.
Yes.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. And you were doing this freely and voluntarily. Are y'all gonna be working on something? Let me know so I can get you in and out. Okay, yes, sir. You are mentally competent to enter your guilty plea. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true, so help you God. State's Exhibit 1. Made a part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I am going to follow this agreement and I'm going to find you are indeed deemed mentally competent. You understand and appreciate the consequences of pleading guilty. Your guilty plea is freely and voluntarily made. You were giving up your rights to a jury trial. And you were entering your guilty plea voluntarily, knowingly, intelligently, and based upon discussions with your counsel. I find that there is enough evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I am not going to find you guilty so long as you follow these terms and conditions of probation. You will be placed on what we call deferred, postponed, or unadjudicated probation. These are normal and customary terms. Most of these terms of probation I have to follow every day, and all of us have to follow. This will be for 5 years. You'll be fined $500.
Where do you want us out?
Here we go. Please see the probation officer and you'll begin probation. Do well, okay? Yes, sir.
All right, let's head up to Wisconsin. I believe Judge Mogan is about to do a sentencing.
There's 24 CF 150, 24 CF 250, 25 CF 21, 25 CF 84, and 25 CF 113. State of Wisconsin versus Aaron Benjamin. The state appears through District Attorney Kevin Schmidt in person. We have Aaron Benjamin in person with his counsels Renee Landgraf and Nicholas Davis. We're set here today in this matter for a plea and sentencing hearing. The parties have reached an agreement, a global agreement in these cases. Who would like to recite it, Ms. Landgraf or Mr. Davis?
Your Honor, I'm only appointed on one case, and that's 25 CF 21. And
I can recite it if you'd like, Judge.
Okay, please do.
You are in 24 CF 150. Aaron will plead guilty to count 4 disorderly conduct. In 24 CF 250, he's going to plead guilty to count 4, which is obstruction, Your Honor. And I don't want to speak for counsel, but I believe in 25 CF 21, he's going to plead to count 2 and OAR. And my understanding is on the 24 CF 150 disorderly conduct, it would be 90 days jail, credit for time served of 120 days, a time period from 7/1/24 to 10/28/24. On the obstruction, Your Honor, which is 24 CF 250, it would be 2 years probation, stayed and imposed 6 months on the obstruction. And then with regard to the 25 CF 21, the operating after revocation, it's my understanding that would be it would be state imposed 30 days And I don't know what the probation period is. Conditions would be AODA assessment follow through, domestic abuse assault assessment, get a valid license. And if he can get the license back, he's eligible for discharge early on the operating after revocation, Your Honor. If he completes the AODA domestic abuse assessment follow through, he'd also be eligible for discharge early on the probation as well. That's what I believe the agreement to be.
All right. Basis for the agreement in the public interest, Mr. Schmidt.
And Judge, the reason most of these are felonies is from the very first case, which was, you don't need much to charge the felony inflicting cause bodily harm on a child. Looking at the totality of the cases, what they really show is Mr. Benjamin consuming alcohol in, I believe, every single one of these events and acting out aside from the OAR, which is just like a different criminogenic need. So the goal of this is to place him on probation for 2 years with time hanging over his head and then deal with the AODA. If Mr. Benjamin were sober, none of these offenses would have happened.
Thank you. We are in victims' rights compliance. Are we having any statement here today, Ms. Bauer?
Not
Okay.
Your Honor, I just need to interject for 1 second. I think when you called the cases, you called 2 other 25 CF cases.
25 CF 21, 25 CF 84, 25 CF 113.
Are those 2 being dismissed and read in along with yours?
I thought Kevin, those would be dismissed and read in, weren't they? Those are the
Yes.
ones? Yes.
The brand new ones?
Mm-hmm.
Okay.
All right, so all of them are going to be dismissed and read in. Okay. All right, so Mr. Benjamin, that is the agreement that you've reached.
Yes.
And I have in front of me the plea questionnaire waiver of rights form for both of them filled out by each of your attorneys. Did both of your attorneys go over these documents with you thoroughly?
They did, yes.
Did they both go over them with you essentially word for word?
Yes,
And do you understand everything on these documents?
I do.
Did you sign both of these documents?
I did, yes.
And so you're stating here today that you are 40 years old and you have 10 years of schooling. You do not have a high school diploma or equivalent, but you can read, write, you understand the English language. Is that correct?
Yes,
No mental illnesses or disorders, but you have had blood pressure medication, but nothing else?
yes, that's correct.
Did both of your attorneys go over your constitutional rights with you?
They did, yes.
Did they go over them thoroughly with you?
Yes,
Do you essentially understand them entirely?
I do.
Do you need me to go over those with you in any more detail?
No,
Do you understand that by pleading guilty, you're waiving and giving up these rights?
I do understand.
You understand that if you're not a citizen of the United States, your pleas could result in your deportation?
I understand.
Do you understand that with regards to the disorderly conduct in 24 CF 150, the state would have to prove that on or around July 1st, 2024, that you in Burnett County, while being in a private place, engaged in abusive, violent, unreasonably loud, or otherwise disorderly conduct, which tended to provoke a disturbance. Do you understand what the state would have to prove?
I do, yes.
Do you understand the maximum possible penalty could be a fine of up to $1,000 or 90 days of incarceration or both?
Yes,
And do you understand that with regards to the 25 CF 21 case in which we're pleading guilty to count 2, the operating after revocation, do you understand the state would have to prove on or around January 24th, 2025, that in Burnett County, Wisconsin, while being a person whose operating privileges have been revoked, you were operating a motor vehicle on a highway during such revocation period or thereafter, and that revocation was a result of an OWI or similar offense. Do you understand what the state would have to prove?
I do understand, yes.
Do you understand that upon conviction, you face a fine of up to $2,500 or imprisonment of not more than 1 year in the county jail or both?
I understand.
Do you also understand that with this, the court may suspend your driving privileges for not more than 6 months.
Understand?
Do you understand that with 24 CF 250, that would be the obstruction charge, the state would have to prove on or around December 7th, 2024, that in Burnett County, Wisconsin, you knowingly obstructed an officer while the officer is doing an act in an official capacity and with lawful authority by failing to obey that law enforcement officer's commands. Do you understand what the state would have to prove?
I do, yes.
Do you understand maximum possible penalty could be a fine of up to $10,000 or 9 months of incarceration or both? Do you understand that?
I do, yes.
Do you also understand that there is an offer that's been presented and an agreement that's been reached between both sides, which would be a straight jail sentence for the disorderly conduct, 90 days of jail with 120 days of jail credit, with the obstruction, 2 years of probation with an imposed and stayed jail sentence of 6 months, and with the OAR to be on that probation and to have imposed and stayed 30 days with certain conditions on probation. So, Mr. Benjamin, do you understand that I'm not bound to follow that agreement?
I do understand that.
Said differently, that I could sentence you all the way up to the maximum possible penalty for these crimes if I thought it was warranted,
I understand, yes.
or I can do any other sentence that I feel would be appropriate given all of these cases, and it could be one sentence for one of the cases, one sentence for the other, and one for the other, and I could have them all be consecutive, and I can impose them for today. Do you understand that?
I do, yes.
Do you still wish to proceed and enter guilty pleas?
I do, yes, Your Honor.
Now, did you go over both of the criminal complaints with your attorneys?
I have, yes.
And essentially in those criminal complaints, it says what happened those days and why you were charged with the crimes. Do you remember that?
Yes.
As it relates to the 24 CF 150 and that disorderly conduct, did you go over that complaint and those facts with your attorney?
Yes.
And are you admitting here today that you in fact did engage in what would be defined as disorderly conduct in the state of Wisconsin?
Yes.
In 25 CF 21, the operating after revoked, did you go over those facts as alleged in that complaint?
Yes.
And are those facts essentially accurate?
Yes.
Are you admitting here today you operated a motor vehicle after a revocation?
Yes.
In 24 CF 250, the obstruction, did you go over that criminal complaint and those facts alleged in that complaint?
We did, yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today you in fact did obstruct an officer by failing to obey that law enforcement officer's commands?
Yes.
Has anyone made, well, first I'm going to ask Ms. Landgraf, may the court use the probable cause section of the criminal complaint in your case to find a factual basis?
Yes, Your Honor.
Same question to you, Mr. Davis.
Your Honor, in both cases, the defense will stipulate some factual basis of both criminal complaints to rise the level of conviction.
Thank you. Has anyone made any threats or any promises to you, Mr. Benjamin, for you to plead guilty today?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Have both of your attorneys represented you competently?
They have, yes.
And they've answered all of your questions?
They have.
And they've looked at these matters thoroughly?
Yes.
Are you satisfied with their services?
I am.
Any questions for the court or for your attorneys before I proceed?
No, Your Honor.
Then as to 24 CF 150, count 3 disorderly conduct. Well, actually it's count 4 disorderly conduct without the domestic abuse enhancer. How do you wish to plead?
Guilty.
As to 25 CF 21, count 2 operating while revoked. How do you wish to plead?
Guilty.
As to 24 CF 250, count 4 obstructing an officer. How do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 3 criminal charges. The remaining counts in those cases and the other cases will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you, Judge. So I've already touched on some of it and stating the public interest. over the totality of these cases, Mr. Benjamin's already spent 120 days in jail. That's the July 1st, 2024 to October 28th, 2024. And the intent is for the DC to take credit for that. That's why there's the 90 days jail on that. 90 days jail with good time is that whole thing. Then with the 2 years probation, that gives us an opportunity to deal with the AODA issues, if there's any domestic violence issues, and to get his license back. Staying imposing, I think, reasonable penalties for those, given what those offenses are, with the 30 days jail on the OAR, which I know OAR could be up to a year in jail, but that's obviously not appropriate for this case, and 6 months for the obstruction, which is largely in part because of all the read-ins. Thank you.
All right, Ms. Landgraf.
Thank you, Your Honor. This is an OAR. I think placing him on probation with an opportunity to get his license is appropriate here. I would note that although I don't represent him on the other counts, I was his attorney on the underlying revocation, so he did serve some additional consequences outside of this agreement.
All right, Mr. Davis.
Thank you, Your Honor. Your Honor, so I'll just start off. I think that any criminal conviction is a serious offense. I know that lawyers like to downplay it. It's just a misdemeanor or it's a low-level felony. He doesn't need to keep racking these up. These aren't a badge of honor. And I know that Aaron's a little bit sick of going through this. I've known Aaron for a long time, and Your Honor, I know that you've probably known him much longer, and you've seen him in your courtroom multiple times. And so I think the issue with Aaron is drinking. I don't think he's an individual that can go and have a glass of wine or have a beer with dinner or watch a game. I think sometimes if he goes out, it's one turns into a bingy habit. And that's just how people are sometimes. So I think Aaron is going to have to keep that in check. It's something where he may want to consider not drinking. And I think that his life will be very fulfilling. It already is fulfilling. He's got children. His significant other is here with him. And I just found out they've been together for 13 years. And he needs to stop dragging his feet. He's still not proposed to her, but I think that will happen when he is finished with this. I want you to know, Judge, that he's always been very responsible and respectful with me. Any appointments I've had, he's always kept them. He's always been involved in his cases. And so I'd ask the court to consider the joint recommendation. I think the need to protect the public will be met with regard to him not drinking and following the rules of probation. And quite frankly, I hope that he does what he's supposed to do so he can be discharged from probation, because I know that annoys him. He doesn't like it. He's even made a comment with the attorneys today that officers are looking for his vehicle. Is that Aaron? Well, I said, Aaron, if you have your license and you're not doing anything wrong, then you can tell the officers, yes, it's me and I'm driving the vehicle legally. And so I hope he gets to that point. I think he expressed to counsel that it's very expensive, but he just needs to save that money up and complete everything he has to. So I ask you to consider the joint recommendation. Thank you very much, Your Honor.
All right, question before I move on to Mr. Benjamin. You made a statement, Mr. Davis, that it costs a lot of money for him to get his driver's license. What are we talking?
Well, he had the money, but he told me that for all school clothing, they spent about $2,000 in the last week for school clothing for the children. So I think he's going to have that money very soon to do what he has to. So he's not using the excuse that he can get it.
No,
he just needs
that's
to.
great. I appreciate supporting your kids that's a great dad. How much money is it going to take for you to get your license? What are we talking, Mr. Benjamin?
I honestly don't know the answer to that. I don't have a number.
Who do you owe?
I guess I was just I understood that I would owe some money to go get my license.
Well, I think, Judge, I think that he has cash on file, and after he pays all his fines, I think he'll have money to go to the DMV.
I want to control that, though. I want to keep it. I want to know, because I want to make sure it gets paid to whomever it needs to get paid to, so we can pay off your fines and fees, so we can get your license, so you're one step closer. Because you're right, Mr. Davis, I have a lot of money in here. I have a lot of money that I know is sitting here that could go towards his license.
I think Aaron needs to make that phone call to find out exactly what it needs to do to reinstate that license. And maybe the court hold on to that money until he gets that number, and we provide that to the court.
And Ms. Landgraf, as the attorney for the OAR, was that something you looked into or had him look into?
Your Honor, he was in jail up until like about a month and a half ago or so. But I did talk with him today. I mean, I asked him how much and he said that he didn't know, but he was going to find out.
You can find out because, well, you know, with taking the plea, I could take all of it if I thought that it was egregious enough here and for a fine and take all of the stuff. I much rather see the money go towards a use, something, to get your license back, or if you have back child support or something like that. But that's not an issue that we're talking about here. It's simply getting your license and making sure that you do have the funds. And here, at least you have the funds. They've kind of been here in the little kitty of your case.
Your
Mr.
Honor,
Benjamin?
yes, the money that you have there is not mine. It was never mine. It was my brother's, like the bond money.
Well, it's mine now.
Okay, well, I was just saying it was never mine, so I never had that money in the first place. And
But the thing is when somebody bails you out, they sign this nice little sheet that says you understand that you're paying this money, the money the court can use for any purpose that the court finds to be associated with the crime.
okay, I understand.
So that's why I'm just saying it's money and you're going to owe your brother back regardless. Because I could take all of it today right now for fines and fees.
Right.
But that's not what I want to do. I want it to best benefit you and best benefit society and the community. And that's you getting your license.
Your Honor, for the OWIs I know that it's between $200 and $250 to reinstate that license. I don't know if he has to do an AODA. I don't know. I don't know. All I know is that I think the $200, $250 will help him reinstate that license.
Your Honor, now that the reinstatement too, and now that I think about it, I believe there was an interlock thing too, which I believe was going to be very expensive. So that was another reason that I don't have the exact number, but I know it costs a lot of money.
That's different. You do have to install that, but there's also a form here that you would fill out and I would sign off for a half price interlock device. Okay. And so you're going to need to do that. You're probably going to need to get that installed. You're going to need SR22 insurance. You may need to have that AODA assessment and follow through again. Those are all things. And if I know the things, then I can give you an idea of, I can probably guess right now in my head, at least for those things. But I don't know if you owe any other past due fines and fees that you have to pay to get your license back. Because some people have 1,000 tickets in Minnesota that they have to pay in order to get Minnesota to uncheck so they can get their Wisconsin license back.
So now would I have to pay for the interlock stuff when I don't have a vehicle in my name? You still have to pay whatever
You have to get a
fees?
vehicle and it has to be installed. Yes.
Okay.
All right. So anything else you want to add, Mr. Benjamin, before I sentence you?
No, Your Honor.
Okay. So when this case first came in front of the court, in black and white, it's scary, obviously, because it had that child abuse intentionally caused harm, which is that H felony involving your family there. And if you dissect that case, as we did in the process of having these hearings, and that case was dissected, it wasn't as serious as that black and white portrays it to be. There was a serious incident that occurred. Your conduct was not appropriate. I think you've admitted that you were drinking. And when you drink, I believe not only did your attorney state it either not only here, but at another hearing, but you've admitted when I drink, I tend to drink to excess and I get a little out of control. And when you're with your family, you know, that's what happened here. I can't remember if I involved your son and I can't remember if it involved playing a game or doing something. And it just escalated. Not that you wanted it to, not that you intentionally caused harm or you, like you took him and you threw him against the wall. You were just a little bit, because of the alcohol, a little bit more gruffy to him and I believe the rest of your family that day. When you're not drinking, Mr. Benjamin, and both of your attorneys have said it, but mostly Mr. Davis, you are a kind and caring father and significant other. No one knows the ins and outs of your relationship and your family dynamic. Nobody does, except for the people inside those four walls. So if you are able to be, kind and caring and giving when you're not drinking, then that is great. And that is what your family needs. Your significant other and your children do. You don't need to be engaged. You don't need to be married in order to be a family. You're a family. So do what you both want and you both want there. Because as long as your children see that you are loving each other, you're supporting each other, and you're supporting the family and raising the children together, then that's a family, and you don't need that ring. So, but if you want it, push for it. That's all there. But Mr. Benjamin, I would love to see that you work a little bit harder on your drinking, on your alcohol issues, and then you won't need to be here. I think all of them stemmed from this. Anytime you've been in front of me has stemmed from alcohol. And that's the issue, and that's the problem. With regards to the disorderly conduct, I am going to sentence you to 90 days of jail, and I'm going to, that's going to be imposed immediately, 120 days of jail credit, so that is a time served. With regards to the OAR, I am going to do the 30 days imposed and stayed, and I'm going to place you on probation for 2 years. I'm also going to place you on probation for 2 years for the obstructing, and do a 6-month imposed and stayed jail sentence for those, for that matter. With regards to the obstructing and the OAR, those are going to be concurrent to each other, but consecutive to the disorderly conduct matter, which you've already sat. The disorderly conduct charge, I am going to assess $443 in fines and fees. With the OAR, I'm only going to assess $200, the DNA surcharge. With the obstructing, I'm going to order $443 in fines and fees. And so we will have remaining money here. If I can see. So there will be $1,900 that's sitting here, that if I find out you need an AODA assessment, then I can send that money to Aurora. If you need $250 to reinstate your license, I can send that to the DMV, have it directed for your use. Obviously, you said that you borrowed this from your brother. You don't want to exhaust all of it, but if it's something that you need to get your license back and to get it back as quickly as practically possible, that is the benefit. I know you're a worker. You're still working at the casino?
Yes.
Yes, you're a worker, you're a hard worker, you're a provider. As Mr. Davis said, you just spent $2,000 on your kids for school. Kids cost money, and you're there and you're doing it. So I know that you're going to pay your brother back. I just know, I have that feeling you're going to do that. So what I'll do is I'll just keep this, but Ms. Landgraf, can you please update the court on what he needs to do in a written letter after Mr. Benjamin finds out? So that the court can direct the money where we need to direct that money.
Yep, Judge, I looked it up online here, and it says that there's going to be a $200 reinstatement fee. Then the driving privilege is going to be restricted to the ignition interlock device, and then I believe he needs to do the. Did you do the OWI assessment yet for the? And then the OWI assessment, it doesn't appear that he has any outstanding like fines or tickets. Just a quick search on CCAP, doesn't appear that he has any outstanding traffic matters.
Okay. All right.
So I don't know exactly how much a OWI assessment is and what it, $100?
$287
for the OWI assessment,
Yes.
$287 plus the $200 reinstatement fee plus the ignition interlock device, and then how much ever the insurance will need upfront.
Yeah, the SR 22 insurance, there's been a case where the individual found what they needed, and I think they need to pay 2 months, 4 months, or 6 months in advance with that. And then the court just sent the money to the insurance company. So we can do that here as well if needed. So the court will state on the record, we're going to keep that money for a period of 4 months and then determine where, hopefully it'll be diverted before then. Well, on probation, AODA assessment, AODA, OWI assessment, and driver safety plan. So you have to do the AODA, OWI assessment plan. And so you want to focus on that OWI part because that's going to kill the two birds with one stone to get your driver's license back and then to be able to meet this condition, okay? So you want to make sure that you indicate that you want to do that OWI assessment, but I have to call it AODA/OWI.
Understood.
Do that domestic violence class. Have you done one with Dave Hatch yet? Have you done a class with Dave Hatch at Restorative Justice here?
No.
All right, so I'll just say the domestic violence class with Dave Hatch, Restorative Justice. Get your driver's license. I am going to put on there as a condition, at least right now, that you get your GED.
I have my GED.
You do?
He does.
I thought it was checked no.
I'm sorry, Judge, I checked the wrong box.
Okay, because I thought it was checked no. So right now I'm going to check it correctly and undo that and I'll initial. Okay, so never mind, you don't need to get your GED. I'm glad to hear that. That's much better. Okay, so that was the AODA, OWI, DV. Get your license. You have gainful employment, but no alcohol. No establishments that have the primary purpose for the sale or the service of alcohol. You may go to the casino, but only for your work-related purposes, at least while you're on probation. I am going to have that caveat and accept that from this, both sides, that with the OAR, once you get your license, then you can discharge early at the discretion of the Department of Corrections, okay?
Okay.
And with regards to that obstruction, if you meet every other condition and so you get your license, you do that assessment, you do the class, you do all that you need to do, then you can discharge early off of probation, again, at the Department of Corrections, at their discretion, okay? You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need to order your DNA. You'll go to the jail and you'll make sure that they have your DNA and you have the ability to request it be expunged from a written letter to the Department of Justice, not to the court, but to the Department of Justice. I believe that covers everything, Mr. Schmidt.
Nothing from me.
Ms. Landgraf?
No, Your Honor.
Mr. Davis?
Nothing further, Your Honor. Thank you very much.
All right, thank you. Then we are adjourned.
Okay, let's head back to Texas with Judge West and we'll finish our day with her.
You can see about, and maybe even call out there and see if they can get it for us real quick. Is Christy here? See if she can work on that maybe real quick. To help us get that printed out and find it for us. That might be the best person for that. All right, you're Eric Gibson, Senior. And Mr. Gibson, in cause number 25 DCCR 1102, you're charged with a second-degree felony offense of sexual assault from March 7th of 2018. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years. Do you understand? Yes, ma'am. And then in cause number 25 DCCR 1103, you're also charged with the second-degree felony offense of sexual assault from June 9th of 2019. Again, that carries the same punishment range if you are found guilty, between 2 years and up to 20 years in prison. Do you understand? Yes, ma'am. And then in cause number 25 DCCR 1104.
He's actually charged in 04 and 05 with aggravated sexual assault.
I haven't said those yet.
I understand. I think we checked off.
I did it right on the tablet. I was letting you know. Okay.
So in cause 25 DCCR 1104, you're charged with a first-degree felony offense of aggravated sexual assault from March 23rd of 2020. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life in prison. Do you understand? And then finally, in cause number 25, DCCR 1105, you're also charged with aggravated sexual assault. And this is from September 26th of 2024. Again, what that means is if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life in prison. Do you understand? I have here on the tablet plea bargain rejections in each of those cases that show that you've signed on with Mr. Rojas, that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty, for you to plead guilty on the, it looks like the aggravated sexual assault cases for 15-year term in the institutional division, to run concurrently on each of those aggravated sexual assault cases, so 15 and 15 that would run at the same time, with dismissals in the 2 sexual assault cases. You have every right to reject that and have a jury decide what to do in all 4 of your cases. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have all of your cases set for trial?
Yes, ma'am.
All right, we'll get that done. I do want to make sure you understand, Mr. Gibson, that after today, I will not accept this plea agreement unless there is new evidence that's received by the district attorney or your attorney between now and when we go to trial. If you want to change your mind and enter a plea of guilty, it would be to something different than this, or it would just be open to the court. Do you understand?
Yes, ma'am.
All right, and so Mr. Gibson, Mr. Rojas has been appointed to represent you. He's one of the attorneys that handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So, Mr. Rojas, you are released, and Mr. Gibson will appoint someone today. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff.
It very much became plea denial day in Judge West's court. That's like 4 of them anyways, I think, that we saw there. So, you know, not something you normally see. A lot of people rolling the dice, but good for them. I hope it works out. This was fun today. I hope you all enjoyed it. I know I did. We'll be back tonight for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. We're going to do something a little bit different on Sidebar. We're going to talk about judgment, but rather than judgment that happens in court, we're going to talk about how we judge each other and sitting in judgment of one another as a society. So a little bit of a different approach to things, and we'll see how it goes. But do join us. As soon as I'm done here, I'm going to get on the old YouTubes and get that scheduled up for tonight. So be sure to look out for that. And we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members. If you're not a channel member, consider becoming one so you can join us for the pre-show. We have fun over there. Go have yourselves a great Tuesday. Hope to see you all tonight and or tomorrow. In the meantime, take care. God bless.